We're now in the final leg. Up until now, we had to really expand our studies. Now we have to contract it, right? We'll be using the board today because there is an upload issue. So we'll be doing the board. So just keep your pen and paper with you today, right? Now, we move to the next set of themes. We'll first do judiciary, do questions on the judiciary, move on, finish up center state emergency, then local self-government, and then we'll finish up bodies. We should be done before time actually today. ठीक है? शुरू करें? All right. Now, when we study judiciary for the prelims exam, what we're essentially going to be studying is the judiciary and the legal system of the country. In the last 2 to 3 years of the prelims exam, the UPSC has started to ask questions in and around the legal system of the country, not as much as about the core functions. And there is a reason behind it. The constitutional provisions around the legal functions are fairly limited, and a lot of it is done on a case-to-case basis. So what we're going to do is, we'll first set up an overview sort of a layer. Then we will do an in-depth of certain key concepts that are necessary, that need to be done, which I think are relevant for the prelims exam. And we'll cover not just the judiciary, but we will also cover what is called the legal system of the country, right? Now, to begin with, we have a fairly complex legal system. Now, before we do get into the legal system, primarily the legal system comprises of 3 elements: the judges, the lawyers, and the people who are approaching the court, right? There are essentially 3 components: the judges, the lawyers, and the litigants. Litigants are the people who come to court to seek redressal from the court. Issues that litigants face, or what are the compositions of litigants, is not particularly relevant for the prelims exam. 70% of our focus has to be on the judicial system, and about 30% has to be on our lawyers. Who are they? What do they do? What are the different kinds of lawyers that exist? Especially in the last year, very recently, we have allowed for foreign law firms to operate in India in a higher capacity that they could. Now, this is done through an agency called the Bar Council and all of that. We'll come to that in a while. So, there is definitely some contemporary context to do this in a more precise manner. So, let us first pick up what is called the judicial system of the country, right? When we're looking at the judicial system of the country, we are fundamentally understanding that there are 2 very important terms that we use, that it is independent and it is integrated. It is independent and it is integrated. Under no circumstances is our judiciary completely independent and completely integrated. It is mostly independent and it is mostly integrated in comparison to the other branches of the government, in comparison to the legislature, and in comparison to the executive. The judiciary is far more integrated and it is far more independent. But to say that the judiciary is completely independent or completely integrated is something which would be wrong. Now, the judiciary has one side of it being independent and integrated. The second is, it has two versions. One, the formal institutional judicial system, and two, you have your informal, or you could say your local judicial system. At the end of the day, what we're essentially trying to do is that more people come to court, more courts are existing, and more people are getting more of their cases solved as soon as possible. These are the four basic issues that a judiciary of any country simply seeks to achieve or wants to achieve. Now, some parts of the judiciary would be formal and institutional, some would be informal, some would be localized. And if there could be specialization in the executive, there could be specialization in the judiciary. And that specialization in judiciary is now commonly known as the tribunals system. So tribunals are formal and institutional, but are somewhere of a midpoint between the judiciary and the executive in terms of its composition, right? So let us first look at the primary structure of the judiciary, which I am sure most of you know. We've got the Supreme Court, we've got the High Court, we've got our district courts, and we've got our local courts. It's a simple ecosystem. Lower courts, district courts, high courts, and the Supreme Court, right? Now, collectively, the Supreme Court and High Court is called the higher judiciary of India. And everything else is the lower judiciary of India. And because tribunals exist at the High Court level, tribunals are also ordinarily understood to be higher judiciary. But there is no formal certification of it. There is nowhere written in any simple understanding. In fact, when we classify Supreme Court and High Court as the higher judiciary, there is no law, there is no textbook that says it's higher judiciary. It's higher judiciary because of what it does. And because you are the higher judiciary, you have two things that the rest of the courts don't. One is a court of contempt, and two is a court of record. A court of contempt and a court of record. The story first begins with court of record. Only and only the higher judiciary is considered to be a court of record. Now let's understand the origin of it. To understand the court of record, we need to understand a question of fact and a question of law. A question of fact is whether something happened or not. A question of law is whether that incident violates the law in the first place or not. And a judicial body is traditionally any organization which is looking at answering both of these questions. Determining a question of fact and determining whether it is a violation of the law. Ordinarily, the lower courts do both of these functions very well, very intrinsically. It is their job. The higher you go up, the more question of law becomes. Under rare circumstances, unless there is something prima facie wrong, or the case has been admitted to these higher courts for the first time, the courts will get into a question of fact. To give you a simple example, if murder has been committed, whether murder was committed or not, what the facts of the case were, what the investigation proceedings were, the lower courts have decided. When you are going on appeal, you are essentially looking at questions of law. Is this an offense of murder? If so, what kind? Was the right procedure followed? Have we gone wrong with principles of natural justice? The High Court of India on a High Court of a state, or the Supreme Court of India on a murder appeal will not question the facts of the murder. It will get into the larger legal questions. And unless it is very, very evident on the face of it that the investigation was botched up, that there was a prima facie mishandling of the entire process, your evidences, your witnesses, your statements, it is only under those rare conditions that the higher courts of India will order what is called a mistrial and then have the entire process start all over again. Clear? Now, determination of this makes us understand what is called a court of record. A court of record simply means two things. One, whatever has been presented before the court is a matter of record. It is on record. Like how whatever is being said on the floor of the parliament is on record. It has a certain value. So if you are presenting a document in court, if you are presenting an affidavit in court, you're giving a statement in court, it cannot be anything but the truth. If you do that, you're good. If you do otherwise, that in itself will lead to a contempt of court. Contempt of court as a principle exists because you have violated the sanctity of courts of record. So there are two things. One, what is being presented before the court during a case and what the court has said to you, what the court has given to you in the form of a judgment. Now, in the legal world, in our world, a judgment, an order, a decree could mean different things. But in your world, in our UPSC General Studies world, they are more or less the same thing. Clear? So, a court of record simply means two things. It means whatever is being presented in front of the court, before the court, has to be true, and whatever the court has declared has a value. The origin of this is common law, because we follow what is called the doctrine of stare decisis, the emphasis on judicial precedent, judge-made law. Judge-made law. If you want a country to have a judge-made law, you better, under all circumstances, give legal sanctity to the order of the court. So that is what is called a court of record. And both our judicial systems at the higher level are courts of record. Why? Because your facts have already been established in the lower courts. You can question facts, argue on facts, debate on facts in the lower courts. Now that you're presenting something here, it better be true. You cannot mislead the court, you cannot mislead the judges, you cannot mislead the lawyers. Clear? Which then brings me to something called contempt of court. Contempt of court is the other side to privileges of the house. It's essentially the same thing. What is privileges for legislatures is contempt of court for judiciary. Now, contempt of court would mean two things. One, you cannot disregard the court. Two, you cannot disregard the judge. You cannot disregard the court. You cannot disregard the judge. Clear? Now, we, unlike privileges, have the Contempts of Court Act of 1971, which identifies criminal contempt and civil contempt. Criminal contempt and civil contempt. Remember, contempt of court is also a reasonable restriction to 19(1)(a). So it has to be read together. So does the Constitution mention contempt? Yes. Does it define contempt? No. But it empowers the Parliament to make laws on contempt. Checks and balances, rule number 4. So the Parliament of India, through the Contempt of Courts Act of 1971, has in a way codified contempt. And it identifies civil contempt and criminal contempt. Civil contempt is where you pay a fine, or you are to issue an apology or a warning or reprimand. Criminal contempt is you may have to pay a fine, or you may have to go to jail, or do both. Civil and criminal contempt is first differentiated on the outcome of it. And secondly, civil contempt is when you are not following or implementing a judgment. Criminal contempt is when you are trying to impugn the reputation of a judge, when you are trying to demolish or destroy or harm the reputation of a judge. Clear on this? Anything beyond this is not relevant for the pre. That is something you have to understand. The Supreme Court has the powers to punish for contempt for itself. But the High Court has the powers to punish for itself and the entire local judicial system. For itself. No. The Supreme Court has the powers to punish for itself. The High Court has the powers to punish for contempt of itself and the lower courts. वही तो बोला मैंने. No. Supreme Court for itself, High Court for High Courts and lower courts. मैं ये पढ़ के आया मेरा कोर्ट. So in a manner, the High Court of India has wider contempt powers than the Supreme Court of India. We could say so in our prelims options. If the prelims option says that the High Courts of India can punish for contempt for a larger number of courts than the Supreme Court, that would be a correct option. Yes. Now the question is why? Why have you done that? One, to give a federal candy, because the states have a negligible role in the appointment or the removal of High Court judges. And two, this is to de-burden the Supreme Court. And High Courts not only are the lead judicial agencies of the state, they are also the lead judicial administrators of the state. The lower courts in a state are functioning under the overall supervision and the administrative umbrella of the High Courts. That is correct. So therefore, they get the powers. Understood? A more legal reason behind this is The Contempt of Courts Act is a parliamentary act. Judges of the lower courts are appointed by the state. So you would want to maintain some sort of a central balance. That higher court judges or high court judges appointed through a national collegium process will therefore be able to do this. Are we clear on this? Yes? So for our prelims exam, what do we need to know as far as common characteristics are concerned? One, the higher judiciary is a court of contempt, has contempt powers, and are courts of contempt, courts of record. Courts of record means two things. One, whatever is presented before a court is a matter of record. And two, whatever the judge has said in an order has the force of law is a matter of record. This is what is meant by court of record. Yes? Why? Because lower courts you will appeal to the high courts. We cannot leave the judge's judgment at the lower court as a court of record status. High court appeals to the Supreme Court are in a very rare number of cases. Most of them have to be disposed of at the high court level. And except for center state disputes, the Supreme Court and the High Court essentially enjoy very similar powers. You add a little bit of a review petition, you add a little bit of a curative petition, you add a little bit of interstate, and you have the Supreme Court of India. You take that away, the Supreme Court and the High Court are essentially performing similar functions. Clear? So, court of record, our points are clear. Contempt of court, mentioned in the Constitution? Yes. Defined in the Constitution? No. Defined as per the Contempts of Court Act of 1971. Identifies two types of contempt, civil contempt, criminal contempt. Civil contempt, disregarding the judgment. Criminal contempt would be disregarding the judge. Now, why is disregarding the judge a criminal contempt? Because it overlaps with defamation. And defamation is a criminal offense. But disregarding the judgment is not a criminal offense. Because it could be a civil judgment in the first place. It could be a civil case. Understood? So this is why. So this is what is called a civil court. This is what is called a criminal court. And we are good to go. Now, the appointments to both the Supreme Court and High Court judges made by the President. The appointments to both Supreme Court and High Court judges is made by the President. As far as the Supreme Court is concerned, not only the appointment, but also the oath. As far as High Courts are concerned, the oath is given by the respective governor. Again, this is nothing but a way to save some time. Clear? Understood? Yes? So, all higher judiciary appointments are done by the President on the advice of the Collegium and the Council of Ministers. In the prelims exam, you will not get a question on what happens if a collegium is rejected or how binding is the binding advice, because this is not in the Constitution. Are we clear on this? Yes. All we need to know is the minimum hurtful law. The President appoints Supreme Court judges on the basis of a collegium and is also, of course, bound by the advice of the Council of Ministers. That's it. Same is the case with High Court. And removals of Supreme Court and High Court judges is done by the Parliament. Now, here is the important part. The removal order may be signed by the President, but the action of removal, the process of removal is by the parliament. So we will not do the same mistake we did with the governor CM issue. If the prelims question comes, Supreme Court, High Court judges are removed by the parliament, that is correct. Even if the order is signed by the president. The removal of Supreme Court and High Court judges is by the president, is by the parliament. Now see, appointed within a judicial setup called a collegium, removed by the parliament. Rule number 4, checks and balances. Are we clear on this? Yes? Good. Now, as far as your lower judiciary is concerned, this entire ecosystem, the lower judiciary, though the chances of this being asked in the exam is fairly low, but judges of the lower judiciary, which is civil courts, criminal courts, district courts, right? Judges of the lower judiciary are appointed by the state government. But how is that done? Let's understand this rather clearly. The state government will conduct a written entrance exam. It will have an interview stage. The interview panel will comprise of High Court judges of that state. But the appointment will be made by the governor. Lower courts, yes. Are we clear on this? This includes Gram Nyayalayas, includes civil and criminal courts, includes district courts. Okay? Now, are we okay with lower judiciary? So, if in our prelims exam we get a question, who appoints judges to the lower judiciary? It would be the governor. Okay? And because in a way, these are executive appointments, they're also removed by the governor. अब ये एग्जाम में आएगा तो हम ऐसे लिखेंगे. There is no impeachment removal process. Members of the lower judiciary is governor and removal and appointment both. Clear? Done. This is our first layer. This is our first layer. Now, in this first layer, we will start adding some additional setups. We will start adding some specializations. The first specialization that we must know of is something called a tribunal. A tribunal will technically exist at this level. All we need to know as far as tribunals and the prelims exam, so this is a very heavy topic for the mains exam because tribunals are about tribunalization of justice, it's about separation of powers, it's about judicial efficiency, it is about specialization of law. We'll come to that in the mains exam. But as far as tribunals are concerned, tribunals will exist right somewhere at a midpoint between the district courts and the high courts. They are above hierarchy in the district court, but they're slightly below in the hierarchy of high courts. Now, our constitution in its original text did not have anything to do with tribunals. We inserted Articles 323A and 323B for tribunals. And all we need to know is what is in 323A and what is in 323B. Simple process. Article 323A and 323B first is differentiated on purpose. Article 323 is with B kind of tribunal. Article 323A, and A for A stands for Administrative Tribunals. Administrative tribunals are for administrative disputes. The civil services, executive agencies. For example, tomorrow when, say, your batch is to be impaneled for promotion and it is not done so, and you think there is a problem with the appointment that has been made to somebody to some post, you can challenge it in your central administrative tribunal or state, depending on what the case might be. Are we clear on this? So 323A refers to administrative tribunals. They are only created by a law made by the parliament. Okay? By a law made by the parliament. Administrative tribunals under 323A only by a law made by the parliament. And it is the parliament which is going to make a law not only for central tribunals but also state. Rule number 2, center stronger than the states. मतलब स्टेट सर्विसेज का भी ट्राइब्यूनल एजेंसी सेंट्रल लॉ बना के दे रहा है. क्लियर? You will have one central administrative tribunal. You can have multiple benches if the need might be, and you will have state administrative tribunals respectively. State administrative tribunals deals with the services which are under the state. Central administrative tribunal deals with the services which are under the center. Everything else is 323B. Everything else. You can make as many tribunals, abolish as many tribunals as you may deem fit. It can be made by a law by the parliament. It can be made by a law by the state legislatures. No problem at all. Clear? So 323B are tribunals for any other reasons except administration. Again, made by a law, by the parliament or state legislatures. Why either of the two? Because you may be making a tribunal on a law which is on a subject in the state list. Or it could be a law which is only for that state. In the last 4 to 5 years, what we have often seen is a constant reshuffling of tribunals. For example, one of the most latest in 2-3 years ago, was when we have abolished the censorship or the cinematography tribunal. So what used to happen was, we had a censor board. You wanted to appeal a decision of the censor board, you would go to this Film Certification Appellate Tribunal, FCAT. Now that can't happen, that tribunal is abolished. Clear? Understood? Now, within these tribunals, you can create a hierarchy. A tribunal and an appellate tribunal. Income tax tribunal, income tax appellate tribunal. Competition tribunal, competition appellate tribunal. Company law tribunal, company law appellate tribunal. We had a very, very well-known tribunal in our 2000s which we shut down, the BIFR. The Tribunal for Banking and Financial Reconstruction and the Appellate Authority for Banking and Financial Reconstruction. Shut both of them down. Idhar hi LIC building mathur CP. Clear? So, if there is no appellate tribunal, then cases on appeal from tribunal will come to the High Court. If there is an appellate tribunal, from here to the appellate tribunal and then the Supreme Court, depending on the tribunal. depending on the tribunal. In the prelim exam, if they ask you, there are no appellate tribunals for administration, that is correct. That is correct. There's the Central Administrative Tribunal. There is no Central Administrative Appellate Tribunal. Which is why Central Appellate Tribunal, Central Administrative Tribunal cases will always go on appeal to the High Court. And then from there you will go to the Supreme Court. The point is a fairly simple one. You've got two kinds of tribunals. One for administration under 323A, two for everything else under 323B. For administration, only the parliament can make a law for it. You will have one tribunal for center and and different tribunals for states. But one tribunal. There will be one state administration tribunal. There will be one central administrative tribunal. Very clear. But this is done through a parliamentary law. 323B, a tribunal for any other reason, can be made by the parliament, can be made by state legislatures, no problem at all. Yes. And you can have appellate tribunals with it. No questions asked, no problem. What is the difference between a tribunal and a court of law? Now that is a prelims question. Right? There are few basic differences. Difference number one. A formal court of law will always have judges of a judicial background, of a legal background. Common law, formal courts. Our formal courts are representations of common law. Our tribunals are representations of continental law. So if you're a judge in this formal legal system, you necessarily need to have a legal background across the board. But tribunals can have people with a legal background, can also be civil servants, can also be experts, can be non-legal members. That is your prelims option right there in front of you in one statement. 2. Formal procedural laws and formal court procedures are strictly bound in our formal court systems. Tribunals, you can ease up those procedures. Evidence, examination of witnesses. Those formality of procedural law does not necessarily apply in what is called a tribunal. Clear? Understood? That is it. As far as our prelims exam is concerned, these two differences are more than enough. In the mains, there is a huge list that we will cover when we do tribunalization. Okay? Tribunals will always exist for a specific branch of law. High courts are generic. They'll look at cases across the nature. Income tax tribunal will only look at income tax cases. Will not even look at GST cases. Will not even look at excise. Will not even look at consumers. Clear? Okay, good. So this becomes your first additional layer. Your second additional layer exists in the form of specialized courts. These specialized courts are parallel to the district court. Most amount of civil cases are family law cases. So what we have started to do in a lot of the states in India is, we now have family courts. Your divorce cases, custody cases, they directly go to the family court. From here, you will go on appeal to the High Court. From here, you will go on appeal to the High Court. Okay? Understood this? Yes? Good. Now comes the third layer. This is like local self-government, but for judiciary. And there are only two that are important. One is your Gram Nyayalas, and second is your Lok Adalats. Gram Nyayalas and Lok Adalats. The basic difference between the two. That's all we need to know as far as the prelims exam is concerned. Are both backed by a law? Yes. A specialized parliamentary law has created both of these. Gram Nyayalaya is governed by the Gram Nyayalaya Act of 2008, and the Lok Adalats are governed by the Legal Services Authorities Act of 1987. Both have a legal backing. Now the difference is very logical. The name Gram Nyayalaya, a court of the villages. District court at the district level, civil and criminal courts at the block level approximately. Yes. And then below that are your villages. They also require legal representation. So therefore, village courts. If a Gram Sabha is the parliament of the village, the Sarpanch is the prime minister of the village, the Tehsildar is the chief secretary of the village, the Gram Nyayalaya is the Supreme Court of the village. Samajh mein aaya? So you basically created an additional layer. They should be able to do what other courts are also doing. So logically tell me, will the Gram Nyayalaya look into civil and criminal matters both? Yes. Because you created an additional layer. In a smaller capacity, lesser cases, less jurisdiction, but total jurisdiction. The Gram Sabha can only make laws on something which it has the powers to make laws on under the 11th schedule. Same goes for Panchayat Samiti, same goes for Zilla Parishad. That doesn't mean they are not legislatures. Whatever powers you have given, they will execute their powers and they will make laws on it. Gram Nyayalayas are essentially those versions. So I have no logical reason, no legal reason to not allow Gram Nyayalayas to have civil and criminal jurisdiction both. So civil cases and criminal cases both, but of a very, very petty nature. Of a very, very petty nature. Very small nature. Now you look at the second term, Lok Adalat. Janta ki Adalat. That reminds you of a fairly annoying TV show. It used to be good back in the day, but now it's just, Janta ki Adalat, Lok Adalat. Right? Janta ki Adalat, Lok Adalat. Cases of the people, for the people, by the people. Trying to dispose of cases as soon as we can, as early as we can, which do not really require a substantial application of the legal mind. So can I look at a murder case in a Lok Adalat? It's a court of the people, for the people, by the people. So judges also don't necessarily have to come from a legal background. So your Lok Adalats only look at civil cases. If the people wanted a court and have been given a court, if the people wanted a court and have been given a court, you finish up there itself. आपका गाय कोई चुरा के ले गया, इसके लिए सुप्रीम कोर्ट जाने की जरूरत नहीं। क्लियर ऑन दिस? एक्सेप्ट फॉर लोक अदालत्स, there is an appeals process for everything in the legal system, because lok adalats are courts of the people. Every case doesn't deserve an appeal. There could be cases where there is no question of law involved. It is a simple determination of wo bakri kiski hai, right? That is why lok adalats exist. So except for lok adalats, you have an appellate system for everyone. So technically, your lower court system is three-pronged: civil courts, criminal courts, and gram nayalaya. Civil courts and criminal courts exist at the same level, and gram nayalayas are at a lower level. Bas. Now with gram nayalayas, it's a part of the formal ecosystem. Lok adalat is nothing but आओ बाहर निपटा लेते हैं. So even if somebody has filed a case in the formal legal system, the district courts can refer it to a lok adalat. क्या आप देख लो ना यार, क्या है, इतना पेंडिंग चल रहा है. So this communication back and forth, cases on appeal from lower courts to higher courts, and cases and judgments of higher courts being applicable to lower courts, this makes the Indian judiciary integrated. This makes the Indian judiciary integrated. Clear? Bas? So if in our prelims option, in a prelims questions it comes, which of the following are interpretations or meanings of an integrated judiciary? An appellate system, the applicability of judgments of higher courts to lower courts, the principle of judicial precedent, yes, the fact that lower courts are under the supervision of higher courts. These are all features of an integrated judicial system. Though more than an integrated judicial system, what is more important is an independent judicial system. And we've understood that as far as an independent judicial system is concerned, it is never truly independent. It can never be truly independent. Understood? Now we take a magnifying glass. Yes, please. Gram Nayalaya decisions are binding to the gram. Of course. Yes. नहीं. Only higher to lower. ठीक है, डन. ये आगे कैसे बढ़ाते हैं? अच्छा, एक सेकेंड. ओके, गॉट इट. हाँ जी, प्लीज टेल मी. कौन बोल रहा है? नहीं, गलत है. ओनली, अब इसमें लॉजिक लगा दे भाई, मैं बता देता हूं. Can I answer his question? It's a beautiful question he's asked. Your question has hurt me, but I will answer. A Lok Adalat does not have the jurisdiction to dispose of all criminal cases. Remember, I told you there were three kinds of crimes: bailable, non-bailable, कॉग्निजेबल, नॉन कॉग्निजेबल एंड तीसरा बता। हाँ हाँ, तू ओफ हो। कंपाउंडेबल, नॉन कंपाउंडेबल का क्या मतलब होता है? A compoundable offense is one which could be settled outside court. A non-compoundable one is which cannot be. So if I'm setting up a court for the people, can I have compoundable criminal offenses taken care of it? Yes. Non-compoundable? No. So can all criminal cases be dealt by as far as the Lok Adalat is concerned? क्या प्री में पूछेंगे ग्राम लोक अदालत कैन ओनली लुक एट कंपाउंडेबल ऑफेंसेस? प्री का पेपर राजेंद्र नगर के लिए नहीं बनता है, पूरे देश के लिए बनता है। आर वी क्लियर ऑन दिस? ठीक। नाउ वी टेक अ मैग्नीफाइंग ग्लास एंड वी अंडरस्टैंड ओनली द हायर जुडिशरी, whether it is the Supreme Court or it is the High Court. Okay? What are the components behind it? And each component will have a certain role to play. First things first, the Chief Justice of India and the Chief Justice of the High Court occupy a special position only on administrative matters. None of the Chief Justice, no Chief Justices have no additional judicial powers. They do not enjoy a hierarchy in terms of judicial powers. If there is a 13-bench judge, including the Chief Justice of India, there's nothing special about this. They enjoy a hierarchy and precedence in terms of the administrative functions of the judiciary. Running the judiciary as an organization. So if in the prelims we get an option that says the Chief Justices of the High Courts are superior to the other judges of the High Court, no. The Chief Justice of India enjoys a higher judicial power than the other judges of the Supreme Court? No. Clear? Then, of course, you have your judges on either sides. You have your lawyers on either side. एडमिनिस्ट्रेटिव पावर कि भाई कितने कोर्ट रूम बैठेंगे, कोर्ट में एसी होगा कि नहीं होगा, केसेस कहाँ लगेंगे, कब कोर्ट खुलेगा, कब बंद होगा. अब वी आर गेटिंग इनटू टेक्नोलॉजी इन द सुप्रीम कोर्ट. यस, तो वो कॉन्ट्रैक्ट्स रिव्यू करना, आर्टिफिशियल इंटेलिजेंस इन जुडिशरी वी आर यूजिंग फॉर ट्रांसलेटिंग जजमेंट्स. हाँ, सो मच पेटी थोड़ी ना हुई है, संस्था चला रहे हो. No, give me a minute. Just give me a minute. It's a semi-administrative function. I'll come to that. Appointment. ठीक है? अपने लोकसभा में सेक्रेटेरिएट और सेक्रेटरी जनरल था ना, जिनका काम था लोकसभा को चलाना, टेबल कुर्सी रेडी रखना, माइक वाइक चेक करना. Similarly, we have administrative departments of these courts. The head of the registrar general or the secretary general of the courts is called registrar. The secretary general of the courts is called registrar. वो पूरी जो कागजी कार्रवाई रजिस्ट्रार के ऑफिस में जाके केस फाइल होता है. क्लियर ऑन दिस? अंडरस्टूड? रुक जाना भाई. ठीक है? Done? Now, the Secretary General also works under the overall supervision of the Speaker. Yes? The Speaker here would be the Chief Justice of India. तो कौन सा केस किस कोर्ट रूम में लगेगा, कब लगेगा, कितने बेंच बैठेंगे, कौन से बेंच पे कौन बैठेगा, उसको क्या बोलते हैं? मास्टर ऑफ रोस्टर. And who's the head? The Chief Justice. It's an administrative function. Clear? Understood? ठीक. मास्टर ऑफ रोस्टर एग्जाम में नहीं आएगा, वो पीटी पढ़ के आया. ठीक है? Done? बस. Now that we've understood this, let us get into the complications of it, which is the appointment procedure. अपने को सिर्फ एक ही चीज से लेना देना है, what is the appointment process as of today. पहले क्या हुआ, क्या नहीं हुआ, मेरे को कोई फर्क नहीं पड़ता है. And I will begin with the question that she has asked, which is the most important question. Is the appointment of judges a judicial function or an administrative function? To put it in one line, it is an administrative function, which is why it can be reviewed, which is why principles of natural justice could apply. But this is again a matter of jurisdiction and legal debate, not relevant for us as far as the exam is concerned. अपने को बहुत सिंपल चीजें समझनी है कि होता क्या है. केस का नाम क्या था, AOR एसोसिएशन, ये सब वो सब बात की बात. Our current appointment system is governed by something called the third judge's case. This third judge's case has given us the way higher judicial appointments have to happen. Clear? Now, these appointments are for the Supreme Court and the High Court judges. Now, in each of these, you must understand that provisions for the Supreme Court and provisions for the High Court judges are governed by a certain set of laws. मैं पहले लीगल आर्किटेक्चर बताता हूं, फिर इसके बाद हम डिटेल्स में जाएंगे. The first set of provisions that govern all of this entire ecosystem is the Constitution of India. The Constitution of India. Second, their removal processes are governed not only through the Constitution, but through a specific law called the Judges Inquiry Act of 1968. So the Judges Inquiry Act of 1968. Third, the third set of laws that we look at is called the Judges Protection Act of 1985, a fairly unknown law which gives you a lot of immunities and protections to judges. So you've got your Judges Protection Act of 1985. And fourth, extremely important again, the Contempts of Court Act of 1971. These are our legislations. Okay? Now, these legislations are common to the Supreme Court and the High Court. क्या हुआ बेटा? आप इधर आइए, इधर आइए, इधर आइए. अच्छा अच्छा अच्छा, आपको लग रहा है हम यहाँ कॉमेडी शो कर रहे हैं? प्री की क्लास है, मुझसे पूछ के तो आ जाते, है ना? ऐसे नहीं कर. शक्ली देखो हमारी, लगे हुए हैं. 2 महीने में प्री है, 1.5 महीने. ठीक, ओके, क्लियर? कुछ मिला आपको सामान? आप ढूंढ लीजिए, हम वेट कर लेते हैं. ठीक है, क्या क्या खोया है आपका? चार्जर था. ओहो, चलो चलो. There are 4 laws which are common to both the Supreme Court. Some specific special laws only for the Supreme Court and only for the High Court. There are two specific separate laws for the Supreme Court. A law that governs the conditions of service of Supreme Court judges and a law that governs the number of judges, right? We've got two separate laws. One law which looks at the conditions of Supreme Court judges and the second is the number of judges. We have seen amendments to this law where we've increased the number of Supreme Court judges, right? Now, the Supreme Court Judges Salaries and Conditions of Service Act is 1958. And you have the Supreme Court Judges Number of Judges Act is 1956. So, which is why when you are changing the number of Supreme Court judges, you are effectively changing two laws. You change the number and you've kept the salary same, one law. If you've increased the salaries, then both laws. If you're also increasing the number of judges. The Supreme Court Salaries and Judges Act is also accompanied by their respective rules. But एक कानून बनाया किसने? Parliament. Which also means सुप्रीम कोर्ट के लिए तो आपने अलग अलग कर दिए, हाई कोर्ट के लिए आपने इतनी मेहनत ही नहीं करी. There is just one law, the High Court Judges Salaries and Conditions of Service Act of 1954. सब कुछ इसी में है. The High Court Judges Conditions of Service Act 1954. All of these laws can only and only be made by the Parliament. By the Parliament. ठीक है? Clear on this? ये तो सिर्फ कानून हुए. इसके ऊपर the Supreme Court has its own rules called its SCR, Supreme Court rules. High courts have their own rules called HCR, the High Court rules. वो rules बनाते हैं, President notify में gazette पे notify कर देता है. They have the powers to make rules of their own procedure. They cannot violate the larger legislative premise, but they have the powers to make their own procedure. ठीक है? Understood this? Specifically for appointments, we have created a separate set of procedure called Memorandum of Procedure. An MOP Supreme Court and MOP for High Court judges. सारा ड्रामा यहां लिखा है कि गवर्नर को बोलेंगे, सीएम को पूछेंगे, मिनिस्टर को पूछेंगे. कॉन्स्टिट्यूशन तो बहुत क्लियर है, अपॉइंटेड थ्रू अ कोलिजियम प्रोसेस. What is going to be the strength of the collegium is third judge's case. आसपास किसको पूछेंगे? मेमोरेंडम में. Rest everything governed different elements. अब क्लैरिटी आई? Which is why we are so varied and so spread out when it comes to Supreme Court regulations. एक सेकंड, ठीक है? Let me just do. The purpose of this when we are stepping into appointments is to understand the regulatory framework or the legislative framework in which our higher judiciary operates, because the pre sometimes picks up options from here. Like in a lot of these removal questions, there was one of the options in the prelims exam that the removal is governed by the Judges Inquiry Act. तो हमको याद ही नहीं इंक्वायरी एक्ट क्या है, अब हिट कर जाएगा. Constitution, laws, rules, memorandum of procedure. These are the four common frameworks. ठीक है? अब between the Supreme Court and the High Court, a set of things which are commonly applicable to both. Provisions of the Constitution, obviously. Judges Inquiry Act, because removal process is the same. Judges Protection Act to provide certain immunities and allowances. Fourth, Contempt of Court Act 1971, because both of them are courts of contempt. Bas. These are the four laws, four legislations which are equally applicable and common to the Supreme Court and the High Court. Okay? In addition to this, there are two laws that have been only made for the Supreme Court, a separate law for salaries, a separate law for the number of judges. Right? So, the number of judges is the 1956 law, the 1958 law is the salaries and conditions of service. The High Court judges' salaries and conditions of service. The High Court judges' salaries and conditions of service is a separate law which has been made under 1954. ठीक है? जितने भी सैलरी वाले लॉज हैं उनके साथ रूल्स अटैच्ड हैं, बिकॉज वो कंडीशंस ऑफ सर्विस भी हैं. अब फॉर एग्जाम्पल अ जज इज एंटाइटल्ड टू अलाउंस फॉर इंटरनेट. अब वो इंटरनेट वाला चेंज करना है तो बैठ के कानून थोड़ी ना अमेंड करेंगे, रूल्स में ही कर दो. क्लियर ऑन दिस? ऑन टॉप ऑफ दिस we have the third judge's case which has judicially reviewed this process, and it is a judicially made process for judicial appointments. And to implement the third judge's case, we have memorandum of procedure. आया समझ में? क्लियर? अब इससे दो तीन डेरिवेशंस निकलती हैं. इसमें से दो तीन डेरिवेशंस निकलती हैं. फर्स्ट, the power to determine the strength of the Supreme Court is with the Parliament. The Constitution nowhere mentions that this is your strength. Have you ever seen number of judges mentioned in the Constitution for Supreme Court? No. Because you can't. This is a very, very fluid number. You have more judges available, there is a higher burden, you will require more judges. Clear? ठीक है? The strength of the judges of the Supreme Court determined by the Parliament. What about the strength of the judges of the High Court? What about the strength of the judges of the High Court? Very good. The strength of the judges of the High Court. You don't even need to make a law to change the number of judges of the High Court. You can simply do it through a presidential order. उसके पीछे एमओपी की कहानी है, बट हमको नहीं जाना उसमें. उसके पीछे बहुत डिटेल्ड प्रोसेस है कि इससे कंसल्टेशन होगा, उससे होगा, ये चिट्ठी देंगे, वो चिट्ठी देंगे. पूरा कोलिजियम प्रोसेस एमओपी में है, पूरा का पूरा. हमको सिर्फ नंबर ऑफ जजेस पता होना चाहिए. आर वी क्लियर? यू रिक्वायर ए पार्लियामेंटरी लॉ to change the number of judges of the Supreme Court. The number of judges of the High Court can only and only be changed through an executive order by the President. Are we clear on this? Understood this? Good. Why? Why is that the case? हम ऐसा कर रहे हैं तो ऐसा क्यों कर रहे हैं? It's an important question. Because the Supreme Court looks into center-state disputes. So changing the strength of the Supreme Court will impact how frequently can we look at center-state disputes. So therefore you require parliamentary sanction on it. And it is a smaller court to change. If every time I would require a law to change the strength of the High Court, we will have to depend on parliamentary action. There are so many, there are 25 plus High Courts in the country. There shall always be a Supreme Court of India. In Delhi compulsorily, no. But there shall always be a Supreme Court of India. So can we create or abolish a High Court? How? How do you abolish a High Court? What do you do? If I want to shut down the High Court of Allahabad, sorry. It is Allahabad only. If I have to shut down the High Court of Allahabad, can I do it? I can create a new bench of the High Court, is it? How do you do that? The states have no role. Sorry? चीफ जस्टिस विद अप्रूवल ऑफ प्रेसिडेंट तो पूरा सिस्टम ही उल्टा पड़ जाएगा. Can I create or abolish a high court? Of course. They are not permanent structures. अरे स्टेट ही नहीं रहा तो logically think about it. If I am merging a smaller state, जब भी मैं कोई ऐसा क्वेश्चन भेजू ना तो just take a step back and think what could be a circumstance in which a high court of the state could be abolished. Is there a merger of the state? A merger of a state? So if there is a merger of the state, that means the high court has to be merged. Parliament. The parliament is conducting it, right? But do we have a High Court of Bombay Act? Because if we could have a High Court of Bombay Act, then the parliament would govern the High Court of Bombay. You can do it through an executive order by the president on advice of the Supreme Court, the Chief Justice. That is correct. But can you abolish? Yes. In your prelims, I'll oversimplify it for you. Can the Supreme Court of India be abolished? No. Can high courts be abolished? Yes. Can further branches or benches be created? Yes. Can there be a single high court for 2 states? Yes. All of this can be done. There is no problem at all. That is why we are an independent judiciary. Independence is not just about appointments. It's about functioning. A very, very important feature of independence. समझ में आ रहा है? Clear? ठीक. Is this framework okay? Are we fine with this? Yes? So if I have to change the number of high court judges then in a particular state, क्या करेंगे फिर? Executive order. You require a parliamentary law to change the number of Supreme Court judges. You do not require a parliamentary law to change the number of high court judges in a specific state. अपने को प्री के आंसर निकालने हैं, ज्ञान बाद में देख लेंगे. ठीक है, done. Now that we are clear, let's come down to the complicated process, which is your appointment process. We are going to do the appointment process in a 3-column form. First, what does my constitution tell? Because pre में आता है according to the constitution. Pre में आता है according to the constitution. According to the constitution, all Supreme Court and High Court judges are appointed by the president. ये सही है? पक्का? According to the understand this is very important. The constitution simply says 3 things. The president will appoint Supreme Court and High Court judges after consulting Supreme Court and High Court जजेस। बस इतना ही लिखा है। इसके ऊपर लगता है गरम गरम तड़का थर्ड जजेस केस का। क्लियर? अंडरस्टूड? नहीं, all we need to know is the current state of appointments. Memorandum of procedure में आता है ना यूकॉम। The president anyways does not have an independent discretion. नहीं, यूकॉम ऑब्वियसली कम्स इनटू प्ले, नो डाउट, बट हमने वो लिखा नहीं है यहां पे भाई, वो तो अज्यूम्ड है। सॉरी, ऑल कॉल्स टेकन बाय द प्रेसिडेंट आर ऑन द एड एंड एडवाइस ऑफ यूकॉम। अब इस प्रोसेस में थर्ड जजेस केस आ जाता है, ठीक है, थर्ड जजेस केस आ जाता है। दिस थर्ड जजेस केस refines the process of a collegium. It refines the process of what is called a collegium. And this third judge's case is implemented by your memorandum of procedures separately for Supreme Court and High Court judges. अब ये बहुत सिंपल है। सुप्रीम कोर्ट के अपॉइंटमेंट के लिए 5 लोगों का कोलिजियम मिनिमम होना चाहिए। दिस इज CJI प्लस 4 सीनियर जजेस। ये किधर लिखा है? इसलिए प्री में आज तक कभी आया नहीं। क्लियर? इट्स नॉट इन द कॉन्स्टिट्यूशन एनीवेयर। वेरी गुड, ठीक है। CJI and 4 senior judges. The Chief Justice of India is appointed on a simple seniority principle as a matter of convention. The appointment of the senior most judge as the Chief Justice of the Supreme Court, or for that matter of the respective High Court, is a matter of convention. It's not even in your memorandums of procedure. Why? Simply because during the emergency and the aftermath of it, this seniority principle was breached. Several judges were therefore, had to resign or resigned in demonstration of protest, and therefore there was a historical muck around that. ये ठीक है? समझ में आया? All other judges are appointed on a consensus basis. अब वो प्लूरैलिटी है, एक दूसरे का हाथ पकड़ के बोल रहे हैं, वो अपने को प्री में इंपॉर्टेंट है नहीं। सर फोड़ेंगे? नहीं फोड़ेंगे। क्यों फोड़ेंगे भाई? But sir, what is the plurality of collegium, sir? Sir, what is concurrence, sir? Concurrence. ठीक है? बस 4 सीनियर मोस्ट जज CJI मिलके सुप्रीम कोर्ट के जज अपॉइंट करते हैं। आर वी क्लियर ऑन दिस? आर वी ओके विद दिस? बस हाई कोर्ट में द CJI एंड हाउ मेनी? 4. हाउ मेनी? 2 सीनियर मोस्ट जजेस। ठीक है, 2 सीनियर मोस्ट जजेस। अब यहां पे थोड़ा सा ध्यान देना है। द जनरल हाई कोर्ट कॉलेजियम इज चीफ जस्टिस प्लस 2 सीनियर मोस्ट सुप्रीम कोर्ट जजेस। बाय द ब्रॉड प्रोसेस ऑफ द जजमेंट में लिखा है इतना, लेकिन हाई कोर्ट वालों को MOP में पूछ लेते हैं। ऐसा नहीं कि नहीं पूछते हैं, लेकिन MOP में। क्लियर? सो द चीफ जस्टिस ऑफ द हाई कोर्ट is again appointed on the seniority principle and the governor is consulted. ये आपका MOP में लिखा है. And the other judges of the High Court are appointed on the consensus, and while they are being appointed, the President can also take a consultation from the Chief Justice of the relevant High Court. ये क्लियर हो गया? ठीक है? दोबारा बता दूं एक बार? हाँ. बहुत ध्यान से सुनना. सुप्रीम कोर्ट का तो अपॉइंटमेंट बहुत क्लियर है. सीनियर मोस्ट जज ऑफ द सुप्रीम कोर्ट CGI. बाकी लोगों को CGI प्लस 4 सीनियर जजेस. ठीक है? यस. अब हाई कोर्ट में द कोलिजियम ऑफ द हाई कोर्ट इज द चीफ जस्टिस ऑफ इंडिया प्लस 2 सीनियर मोस्ट सुप्रीम कोर्ट जजेस. कैन दे बी द सेम जजेस? यस. कैन दे बी डिफरेंट जजेस? यस. Depending on who is the senior most at that time of appointment. ठीक है? Now, the Chief Justice of the High Court, like the Chief Justice of the Supreme Court, is chosen on a seniority principle. But एक बार अपॉइंट करने के पहले गवर्नर से भी पूछ लेते हैं. ठीक है? कौन पूछते हैं? कोलिजियम पूछता है. बिकॉज एक इंटरनल प्रोसेस है. Then comes appointing judges of the high courts who are not chief justices, other judges of high courts. A consensus process of the collegium. Are we clear on this? Yes. And वो collegium recommendation president को चला गया. एक बार president will send it to the chief justice of the high court कि भाई ठीक है ना, कोई दिक्कत तो नहीं, बस एग्जाम में आएगा नहीं, क्योंकि ये MOP में. आर वी क्लियर? बस इसके ऊपर हमको अपॉइंटमेंट्स कॉम्प्लिकेट करने ही नहीं है. हु इज डिलीवरिंग द ओथ टू सुप्रीम कोर्ट जजेस? प्रेसिडेंट. हु इज डिलीवरिंग द ओथ टू हाई कोर्ट जजेस? गवर्नर. क्लियर? ओके, गुड. ये तो हो गया बनते कैसे. Now we come to a larger question, which is qualifications. Who is qualified to become a judge of the Supreme Court or the High Courts? ठीक है? ध्यान से सुनिएगा. ये बहुत सिंपल है, so there is nothing to worry about. Okay. We've done this in the legislature also before. We've done this when we were discussing parliamentary finances also. So first things first, what are your common qualifications? Both have to be a citizen. Yes, both should have either been a lawyer for 10 years. To be a Supreme Court judge or a High Court judge, you should have been a citizen, or you should have been a lawyer for 10 years. इतना है तो सुप्रीम कोर्ट जज भी बन सकते हो, हाई कोर्ट जज भी बन सकते हो, कोई प्रॉब्लम नहीं. ठीक है? लेकिन सुप्रीम कोर्ट जज बनने के लिए यू हैव मल्टीपल अदर ऑप्शंस ऑल्सो. यू कुड हैव बीन अ हाई कोर्ट जज फॉर 5 years, राइट? और अ डिस्टिंग्विश्ड jurist. So your Supreme Court qualification criteria is citizen, High Court judge for 5 years, lawyer for 10 years, or a distinguished jurist. Why a distinguished jurist? Because you are getting into interpretations of the Constitution. We require sometimes legal academics, legal professors, theorists of law to give you a better interpretation of the law. ये clear हो गया? Citizen, High Court judge for 5 years, High Court lawyer, a High Court lawyer for 10 years, or a distinguished judge. ये नहीं कि लोक अदालत में 10 साल से हम जाके सुप्रीम कोर्ट में जज बने. हाई कोर्ट, बिकॉज मोस्ट ऑफ द वर्क इज द हाई कोर्ट लॉयर for 10 years. Either of the four, either. The only thing compulsory is you've got to be a citizen in any manner. You're either a High Court judge for 5 years or you've been a High Court lawyer for 10 years, or you are a distinguished jurist. You fulfill any of the criteria, you are qualified to become a Supreme Court judge. आएगा lawyer, advocate, barrister, jurist, lawyer and judicial office. A judicial office is anybody who's deciding on a judicial question. A lawyer is anyone who's arguing before a judicial office. है ना? A lawyer is not a judicial office. A lawyer is an officer of the court. ठीक है? क्लियर? और हाई कोर्ट के लिए क्या है? सिटीजन, a high court judge for 10 years, sorry, a high court lawyer for 10 years, or any judicial office for 10 years. आप डिस्ट्रिक्ट कोर्ट के जज थे, सिविल कोर्ट के जज थे, कंज्यूमर फोरम में कहीं जज लगे हुए थे, ट्राइब्यूनल में कहीं 10 साल से पढ़े हैं, बन सकते हैं. ठीक है? 10 साल. This is the basic qualification difference. What is special for High Court is you can be having a judicial office for about 10 years. ठीक है? अब ये 10 years सक्सेशन में नहीं है, 10 years in टोटो. आप 1 साल का सबैटिकल लेके जाके पढ़े हुए कहीं पे तो कोई दिक्कत नहीं. 10 years की आपकी प्रैक्टिस होनी चाहिए, वकालतनामा होने चाहिए 10 साल के आप दिखा सकते. क्लियर? ओके, ऑलराइट. लॉयर भी 10 years. हाई कोर्ट के, हाई कोर्ट. इन टर्म्स ऑफ अ प्रोफेशनल क्वालिफिकेशन, इफ यू आर ये बहुत ध्यान से सुनना, बहुत इंटरेस्टिंग बात है. A lawyer with a high court experience for 10 years can become a Supreme Court judge also, can become a high court judge also. Why? The same legal experience, the same lawyering experience makes you eligible to becoming a Supreme Court judge or a High Court judge. Except center-state disputes, Supreme Courts and High Courts have effectively same powers, same everything is the same. And the only people who argue center-state disputes are attorney and advocate generals. And attorney and advocate generals anyways cannot be eligible for Supreme Court, High Court appointments because of office of profit. If you are a High Court lawyer for 10 years, it simply means you're a High Court lawyer who's not an attorney general or an advocate general. अगर वो तो आप ऐसे भी एलिजिबल नहीं हो, राइट? आप काम तो सेम ही कर रहे हो, which is why you have a common experience. That is why it doesn't say you have to be a Supreme Court lawyer for 10 years to be a Supreme Court judge. But technically there's nothing called a Supreme Court lawyer in terms of what the Supreme Court does. A private Supreme Court lawyer will do everything exactly the same as a High Court lawyer. वो बोलने में अच्छा लगता है यार सुप्रीम कोर्ट में प्रैक्टिस कर, कोई में लीगल फर्क नहीं है. What I would argue before a Supreme Court bench and what I would argue before a High Court bench is essentially very similar kind of cases. Clear? Understood? Yes? ये आपके क्वालिफिकेशन याद हो गए? अगर याद हो गए तो जल्दी जल्दी मुझे आप बताओगे, मैं लिखूंगा. सुप्रीम कोर्ट एंड हाई कोर्ट, गिव मी कॉमन क्वालिफिकेशंस फर्स्ट. सिटीजन, और डिस्टिंग्विश्ड जूरिस्ट, डीजे. यस. हाई कोर्ट का स्पेशल बता दो. any judicial office for 10 years. बस हो गया. The Indian judicial system is a career judicial system. पूरा का पूरा प्रोसेस अपॉइंटमेंट बेस्ड है. इट इज द जुडिशियल सर्विस. यूएस में ऐसा नहीं है. जजेस आर इलेक्टेड. कोई भी जज बन सकता है, इलेक्शन जीतना पड़ता है. हाउ यू हैव अ करियर डिप्लोमेसी इन द फॉरेन सर्विसेज, you have career administration in the administrative services. This is a career judiciary. आपकी सर्विस है तो अपॉइंटमेंट है तो रिटायरमेंट है. हमेशा ध्यान रखना, if the service has a regional component, if the service has a regional component, the organization has a regional component, the state retirement will be 62 and the central retirement would be 65. या कहीं पे भी लगा के देख लो. यूपीएससी, एसपीएससी, फाइनेंस कमीशन, इधर इधर कहीं भी करके देख लो, सेम ही है बस. Why? Because even if you're retiring from here, your eligibility is you can be a high court judge for 5 years. आते आते रिटायर हो गए तो सुप्रीम कोर्ट मिलेगा ना. करेक्ट. एंड we've done this in parliamentary finance. The salaries and the pensions of Supreme Court judges, the salaries and the pensions of Supreme Court judges are with the Consolidated Fund of India, whereas the salaries are with the Consolidated Fund of the state, whereas the pensions are with the Consolidated Fund of India, because the Supreme Court and the High Court rules are very clear. The Judges Inquiry Act is very clear that if you're retiring as the High Court judge, you cannot practice in the states that you have been a High Court judge in. And if you're retiring as a Supreme Court judge, you cannot practice in the Supreme Court and any of the high courts. It doesn't say anything about arbitrations. So can retired Supreme Court or High Court judges be arbitrators? Yes, absolutely. होते ही हैं. Clear? पक्का बता रहा हूं मैं. Suppose Reliance and DMart, the two biggest retail chains in the country as of now, let us say they get into a joint venture to create, say, a third product. Millions of rupees are involved. Contracts are going to be executed. What they will say is, if we have a dispute between the two, we will not go to the formal courts. We will go to an arbitration. Arbitration is nothing but formal out-of-court settlement. Arbitration is nothing but a formal out-of-court settlement. We have an Arbitration Reconciliation Act. The awards that are given, the decisions that are made have a legal standing. And depending on the nature of arbitration, we may appoint a retired Supreme Court judge, a retired High Court judge, sometimes senior lawyers also. The fees is very high. The fees of a retired Supreme Court judge to be an arbitrator, I think, is approximately, on an average, at least 2 to 3 lakhs a day. हाँ, एक साइन की 50,000, ऐसे कौन बोलता है? ऐसे कुछ नहीं. Are we clear? So arbitration, which was supposed to be a faster and a cheaper way, has actually now become more expensive because arbitration is a very expensive process. हो गया क्लियर? यस, ठीक है। नहीं, डिस्टिंग्विश जूरिस के लिए कोई क्राइटेरिया नहीं है। कोलिजियम। कि मतलब आप जब प्रेसिडेंट आइडेंटिफाई करेगा ना, कोलिजियम क्राइटेरिया दे सकता है। इफ यू आर अपॉइंटिंग अ सुप्रीम कोर्ट जज who is somebody who's a distinguished jurist, it is not a direct appointment by the president. The collegium will identify, the president will agree, and then the appointment will be made. ठीक है? I think one of our first Supreme Court judges was not even a lawyer. One of our first chief justices or Supreme Court judges in the early 10 years or so after independence, they were not even a lawyer, they were a jurist. कुछ उस तरह से था. The only non-lawyer to be a Supreme Court judge, I think, the first 10-20 years. चलिए, प्री के लिए रेलेवेंट इतना ही है. आगे बढ़ते हैं. अब रिमूवल देख लेते हैं एक बार. बस 10-10 मिनट में इतना करके आगे बढ़ेंगे. किसी को कोई दिक्कत? सवाल निकल जाएंगे भाई. चलिए, रिमूवल. So what happens is, removal is governed in two manners. First is the Constitution of India, which gives you the grounds, and you have the Judges Inquiry Act, which gives you the procedure. This procedure is, of course, in conformity with the Constitution. ठीक है? Now, what are your grounds? This is very important. The Constitution of India technically just gives you two grounds: proved misbehavior and incapacity. Proven misbehavior or incapacity, and it identifies the parliament as the authority to remove. ठीक है? Are we clear on this? ठीक है. Now, इसका प्रोसीजर थोड़ा सा कॉम्प्लेक्स है, सुन लेते हैं, एग्जाम में आएगा नहीं. ठीक है? सबसे पहले, if you have to remove the Supreme Court or the High Court judges, the procedure is exactly the same. The grounds are the same, the authority is the same, the procedure is the same. It is identical. There is no difference whatsoever, even in removing the Chief Justice of India, because they have equal judicial powers. You're removing them because they've faulted on their judicial powers, which have made them incapable to effectively discharge judgments. Clear? So, the story begins with what is called a removal motion. It is a substantive motion. This could be introduced in either of the two houses of the parliament. Either it is in the Lok Sabha or the Rajya Sabha. If it is in the Lok Sabha, at least 100 people should want this to be considered. So the removal motion that will be submitted to the Speaker and the Secretariat in the Lok Sabha will have 100 signatures. If it was introduced in the Rajya Sabha, then it would have 50 signatures. Removal proceedings of the Supreme Court or the High Court judges can be introduced in either houses. And once introduced in either houses, has to definitely be conformed to by the second house. ये नहीं है कि अगर लोकसभा में मोशन हो गया है इंट्रोड्यूस तो राज्यसभा में भी मोशन लगेगा पहले. नहीं. Once either house has taken up the removal processes, the second house will have to comply. Clear on this? Understood? Now, this motion is placed before the presiding officer. The presiding officer has the powers to accept or reject. On what grounds? Not mentioned. So can a removal motion of a Supreme Court or a High Court judge be rejected by the presiding officer? Yes. Once it has been admitted by the presiding officer, a 3-member committee is formed. This is the procedure as per the Judges Inquiry Act of 1968. That's the next step. This 3-member committee will have a CGI or a Supreme Court judge. That's number one, first member. The first member will either be the Chief Justice of India or the Supreme Court judge. If the removal is of the Chief Justice of India, then the senior most Supreme Court judge. If it is about a Supreme Court judge, then CGI. 2. The same process, either the Chief Justice of High Court or another judge of the High Court. Clear on this? Third, a distinguished jurist. Distinguished jurist, जिसको कानून आता हो. I am a distinguished jurist. Yes. First, a motion is presented to either the Lok Sabha or the Rajya Sabha. Are we clear? This motion can be accepted or rejected by the presiding officer. Are we clear? Once it has been accepted or rejected by the presiding officer, then a committee has to be formed. This committee will have 3 people in it. Either in the first setup, the first person will either be the Chief Justice of India or a Supreme Court judge. If you're removing the CGI, then the Supreme Court judge. If you're removing the Supreme Court judge, then the CGI. 2, the same thing gets replicated, a Chief Justice of the High Court or a judge of the a High Court judge. Again, the same thing. If you're removing the Chief Justice, High Court, then a senior most judge. If you're removing a judge, then the CGI. Third, a distinguished jurist. Anyone who has deep knowledge of the law. And jokes apart, this is a very, very intense knowledge of the law, immersive knowledge. D.D. Basu could be considered a distinguished jurist. MP Jain could be considered a distinguished jurist. Okay? Clear? All right. Now, some key important observations. 1. When you're removing somebody through the committee process, both the Supreme Court and High Court judges are represented. And because you are not just removing purely on legal defunct grounds, a distinguished jurist is also represented. Okay? That is how the removal and the appointment processes differ. When you're appointing a Supreme Court or a High Court judge, the collegium officially only consists of Supreme Court judges. But when you're removing them, the committee will consist of both Supreme Court and High Court judges. Clear? A, because of integrated judiciary. 2, because of independent judiciary. And C or 3, because the Supreme Court looks at center state issues. High Court gets affected by what the Supreme Court has determined on it. Understood? Now, if the committee says not guilty, to baat khatam, not guilty. The process ends. If the committee says yes, guilty, then the houses will come to vote. Special majority 2. We've discussed in our first lectures. More than half, more than 2/3 of present and voting. In such a way, it is more than half of the total strength of the house. A committee recommendation is not binding. Whatever the committee says does not have to be compulsorily adhered to by the house. If there was the case, then why would you have majority in the first place? If the committee has said guilty, then the house will vote on whether guilty or not and therefore remove. But if the committee has said not guilty, no problem, go home, carry on with work. So in a way, this is where most people, we tend to often not get into it. At the end of the day, whether the parliament will officially vote or not will depend on the findings of the committee, which is a judicial committee dominantly. It is a judicial committee dominantly. You've got judges of the Supreme Court and the High Court and a distinguished jurist. That distinguished jurist could perhaps be away from the judiciary. Right? This is why there are larger discussions on collegium appointments. This is why there are larger discussions, and this is why we had the National Judicial Appointments Commission in the first place. Because both the appointment and the removal process. See, an ordinary understanding of the removal process would mean that the parliament is removing the Supreme Court and the High Court judges, so it is fair. But the parliament can only decide to remove if a committee comprising majoritively of the judges says that the person is guilty, or the person in fact has committed proven misbehavior or incapacity. That becomes the roadblock. The committee says not guilty, has not committed it, the parliament will not vote. If the committee has said yes, the person can be charged for proved misbehavior and incapacity, then please. Yes. Are we clear on this? Understood? And once the parliament has passed, then the president will sign the removal order. Because if the appointment has been done by the president, the removal order also has to be signed by the president. Are we clear on this? Understood this? Yes? Sure? Good. Done? Now we come to the jurisdictions, which is important. कोई डाउट? अगर कमिटी ने बोला नॉट गिल्टी तो बात खत्म, लेकिन कमिटी ने बोला गिल्टी, दैट एम्पावर्स द पार्लियामेंट टू वोट. दे कैन वोट नॉट गिल्टी. बस बात खत्म. कैन अ डिसीजन ऑफ द अच्छा नहीं, बिकॉज प्रोसीजरल है ना. थिंक अबाउट इट. इफ द रिमूवल ऑफ अ सुप्रीम कोर्ट जज कैन बी चैलेंज्ड इन द सुप्रीम कोर्ट, तो मतलब देखो, अगर पीएनजे वायलेट हो रहा है तो द प्रिंसिपल्स ऑफ नेचुरल जस्टिस कि मौका नहीं दिया बोलने का, एविडेंस नहीं दिखाया, देन यू कैन गो, बिकॉज this is an administrative process. It's a quasi-judicial process, but it is of an administrative nature. So when the committee is inquiring and the committee is getting into, yes, the judge has done this, you should be informed of it. You should be allowed to defend yourself. You should be allowed to get legal representation if needed. You should be given the evidence before you. The reports have to be shown to you so that you can counter them. That is fine. Okay? Good. Removal, not impeachment. कि कौन सा सुप्रीम कोर्ट जज बैठेगा और कौन सा हाई कोर्ट जज बैठेगा. अगर सीजीआई है तो सीजीआई बैठेगा, नहीं है तो सीनियर मोस्ट जज बाय कन्वेंशन. एक सेकेंड. What you're essentially asking is, if in that committee I can get judges who are arguably perceived to be pro-government, because that would help the outcome of it. That is not necessarily mandated under it. बोलिए. Sorry. प्री में आएगा तो लिखेंगे सुप्रीम कोर्ट जजेस आर रिमूव्ड बाय द पार्लियामेंट. द प्रेसिडेंट इज जस्ट मेकिंग इट फॉर्मलाइज्ड. यही तो गलती हमने गवर्नर वाले, सीएम वाले, उसमें चीफ सेक्रेटरी वाले क्वेश्चन में करी थी. कर तो सीएम अपॉइंट रहा है, बात खत्म। तो फॉर्मल प्रोसीजर है। चलिए, jurisdiction is the power of the court to hear something, and what we need to primarily do is Supreme Court jurisdiction. हाई कोर्ट jurisdiction नहीं करने की जरूरत है कि कौन सा सिविल केस, कौन सा क्रिमिनल केस, कौन सा हाई कोर्ट में जाता है, ये लॉ ऑप्शनल नहीं है, और लॉ ऑप्शनल में भी नहीं आता unless it's constitutional law. There are 5 kind of jurisdictions and I beg to differ from our official textbooks on this. First, original jurisdiction. पहले लिख लो original. First is original, then is appellate. मैं लिख देता हूं original, appellate. The two most important ones: original, appellate, extraordinary, advisory, and plenary. Original, appellate, extraordinary, advisory, and plenary. बस एक एक लाइन में आना चाहिए इसका मतलब क्या होता है, ठीक है? ओरिजिनल, अपेलेट, एक्स्ट्राऑर्डिनरी, एडवाइजरी एंड प्लीनरी. रेडी? ओरिजिनल मतलब द फर्स्ट कोर्ट यू गेट द केस टू. Under what circumstances can you come to the Supreme Court as your first court? There are only two reasons: writs under 32 and center state disputes under 131 clause 1. Writs under 32 and center state disputes under 131 clause 1. Writs we have already covered and you have center state disputes under 131. इसका मतलब सेंटर वर्सेस स्टेट्स, स्टेट वर्सेस स्टेट्स, सेंटर वर्सेस स्टेट 1 प्लस स्टेट 2 प्लस स्टेट 3, सेंटर वर्सेस यूनियन टेरिटरी हो ही नहीं सकता बिकॉज यूनियन टेरिटरी सेंटर का है. बट सेंटर वर्सेस दिल्ली, हाई कोर्ट, हाई कोर्ट, हाई कोर्ट ऑफ Delhi. Clear? Understood? They currently still, the Supreme Court case is still going on. 2 बार क्वेश्चन आए हैं मेंस में यहां से, जजमेंट के पहले, जजमेंट के बाद. ठीक है? बस ये क्लियर हो गया. वन सेक. These are the 2 most important original ones. कि नया नया केस, ताजा ताजा केस आया है. इसके अलावा 2 और छोटे ओरिजिनल jurisdictions हैं which we often sort of ignore. One is transfer petitions. Transfer petitions. This is under 139A, मतलब 139A1, 139A2. अब ट्रांसफर petitions क्या होते हैं? First, you're transferring from the High Court to the Supreme Court. 2, you're transferring from one High Court to another High Court. Both is possible. We are referring to transferring between the High Court to the Supreme Court. Because the High Court and the Supreme Court have very similar jurisdictions. So the Supreme Court is already hearing a case which has similar facts and similar questions, it can be transferred. A transfer petition is not the same thing as a special leave petition. Special leave is an extraordinary provision. Transfer is कि यहाँ कर लेते हैं, it's more logical, it's more administrative, it's more convenient, it is logistically better that the Supreme Court does this. समझ में आ रहा है? Understood? You're looking at the same question of law, the broad facts are the same, and so on and so forth. And then fourth, the last type is a presidential and a vice presidential dispute. Article 71. So सुप्रीम कोर्ट का दरवाजा आप पहली बार 4 बातों पे खटखटा सकते हैं डायरेक्टली. Number 1, a dispute between the center and the states, or a dispute between states and states, or a dispute between center and a collection of states. 2, if your fundamental rights have been violated and under 32 you've come to the Supreme Court. 3, transfer petitions. बहुत कॉमन है ये. For example, there are multiple petitions filed in multiple high courts challenging the constitutionality of the Aadhaar Act. और सुप्रीम कोर्ट में भी पिटिशन है. सुप्रीम कोर्ट आ जाओ ना इधर, साथ कर लेते हैं. आओगे तो यहीं कल. CA. Multiple petitions challenging the constitutional amendment, the Citizenship Amendment Act for 2019 were filed across high courts in the country. A petition was filed in the Supreme Court also. That is why वो देखते हो ना, Putswamy and others versus Union of India, others transfer petition. भाई हाँ, सेम केस 4 जगह लगा रखा है. हो सकता है ना. You may have a problem with the Aadhaar Act, you may have a problem, you may have a problem, you may have a problem. And all 4 of you would have come from 4 different states and would have filed petitions challenging the constitutionality of the Aadhaar Act in 4 different states. And our gentleman over here would have filed a case in the Supreme Court. His name is Justice Putswamy. You are Subramaniam Swamy. You are Arundhati Iyer. You are Arundhati Iyer, sorry. Correct? So, the Supreme Court will say, all right, let's bring all similar cases, we'll finish it up here. Because both Supreme Courts and High Courts have equal powers to pronounce the constitutionality of a law. The only difference is the geographical application of the judgment. Clear? One second. And 4th, presidential and vice presidential disputes. Yes. Then to if there's jurisdictional breach that the High Court can't get into it, then you can go on appeal and argue that the High Court judgment is invalid. You can't issue a writ of certiorari. Clear? Original समझ में आया? 4 बातें हैं. Then after original we have appellate. कि lower से higher. ठीक है? Lower से higher. Civil appeal, criminal appeal. ठीक है? 132 is generally general appeal, 133 is civil, 134 is criminal. आर्टिकल नंबर याद करने की जरूरत नहीं. अपील पे जा रहे हो तो हाई कोर्ट से एक सर्टिफिकेट ऑफ अपील लगता है. एग्जाम में आएगा नहीं. मैं अपने नॉलेज झाड़ रहा हूं. हाँ. थर्ड, extraordinary appellate jurisdiction. Extraordinary appellate jurisdiction is the third kind of a jurisdiction of the Supreme Court. यहां पे you have special leave petition. Article 136, very important for the prelims exam. बहुत ध्यान से सुनना, बहुत ध्यान से. A special leave petition can be from any lower court, any judicial organization, any tribunal, doesn't matter. कोई हाई कोर्ट का सर्टिफिकेट ऑफ अपील नहीं चाहिए, कुछ नहीं चाहिए. If your case involves a substantial question of law or it could impact a gross violation of justice, so you can take the leave of the lower court, it could be a gram nyayalaya also, and come straight to the Supreme Court. कि सर ये इंटरप्रिटेशन का सवाल है, 20 साल बाद आएंगे तो आपके पास ही, और अगर आपने ये अभी नहीं किया तो देश में क्या क्या हो जाएगा. A special leave petition is nobody's right. It has to be admitted in the Supreme Court. You have to argue first. You have to first एक तो convince the Supreme Court. Can you please take this up? and before that you have to sort of sympathize with the lower judges कि आपके औकात के बाहर है, आप important है, बिल्कुल है, रहने दीजिए. ठीक है? Clear? SLP admissions are not very easy, by the way, because when especially SLP petitions from high courts, because what you're effectively telling the Supreme Court is that lower court is incompetent to deal with this matter unless you have very strong reasons to. The court will never take this up. So SLP petitions को admit कराने के लिए पहले कभी कभी सीनियर एडवोकेट लग जाते हैं कि सर आप admit करा लीजिए, बाकी हम देख लेंगे. Admit तो कराइए. ठीक है? This is called extraordinary. Then you have what is called advisory that we've done with respect to the president before. 143(1), 143(2). Now, बहुत ध्यान से सुनना, this is very important. There are two kinds of advisory jurisdictions. We only read of one. Advisory is first with respect to your president. The second is with respect to removing a public service commission member. उसमें भी सुप्रीम कोर्ट इंक्वायरी लगती है ना, कैसे भूल जाओगे? Right? So in an advisory capacity, the Supreme Court works in two forms. First, advising the president on a matter, and two, advising on a matter concerning the removal of either Union Public Service Commission members or State Public Service Commission members. Clear? Good. Now, two kinds of questions the president can ask the Supreme Court. We've done this before. One could be a question on general public importance, which the Supreme Court can say, I will deny to respond. And second, a question arising out of a pre-constitutional treaty. So if the president is asking the opinion of the Supreme Court on a matter which has arisen out of a pre-constitutional arrangement, then the Supreme Court must respond. In reference Berubari Union, however, if it is on a matter of general importance, the Supreme Court may or may not respond. When it responds, it is called in reference Kerala Higher Education case, your DPSP FR case. Clear? The advice once given by the Supreme Court to the president is not binding. Because even if it were binding, then we would not need judgments after Kerala Higher Education to give further clarification. Understood? Good. Now, there is an inquiry that the Supreme Court will do if it is a question of a removal of a Public Service Commission member. That inquiry report is then submitted to the president and the removal has to happen. When we do bodies today after lunch, you will understand UPSC members recruited and removed by the center, State Public Service Commission members recruited by the states but removed by the center, because this is about the permanent executive. So you're creating another additional layer of a check and balance. Okay? Then comes the plenary powers of the Supreme Court. कि इंसाफ की आड़ में हम कुछ भी कर सकते हैं. इंसाफ की आड़ में हम कुछ भी कर सकते हैं. समझ में आ रहा है? There are two plenary powers. One is a review petition under 137. The second is a curative petition under 142. ठीक है? Two plenary powers. Plenary समझते हो? Collective. Plenary session of the General Assembly. Collective. In the interest of justice, मैं कुछ भी कर सकता हूं. सुओ मोटो वो मोटो सब इधर ही आ जाता है. या plenary powers. 137 review petition, 142 curative. Do we need to know article numbers for the prelims exam? No. But बहुत simple है. A review petition is to review any Supreme Court judgment. बस. कितने जज बैठेंगे डिपेंड करेगा बेंच कितना था पुराना. बस. A review petition is to review an existing Supreme Court judgment. ऐसा नहीं है कि आपने रिव्यू पिटिशन फाइल करा तो कोर्ट सुनेगा ही सुनेगा. You'll have to first explain to the court why you need to review a judgment of the same court again. It could be an error in law. It could be an error in facts. Sorry? हाँ 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 कुछ बहुत मेजर चेंज हुआ है. ठीक है. क्यूरेटिव is for any reason. कुछ भी. Can be filed by anyone, can look into anyone. Suo motu powers are derived from curative powers. 142. आया समझ में? Yes? Yes or no? आपको बस कोर्ट के सामने ये बोलना है कि there is a gross miscarriage of justice. We have to prevent the abuse of the law. The last suo motu case, and this is a common misconception that Supreme Court does a lot of suo motu. No, very few. Suo motu का क्या मतलब होता है कि फाइल मत करो, मैं खुद ही बुलाएगा हवा. The last suo motu the Supreme Court did was review of oxygen management during COVID. One suo motu case an entire year. Very few cases. ठीक है. रिव्यू समझ में आया, क्यूरेटिव समझ में आया. मेंस में इसमें बहुत लंबी कहानी है, लेकिन प्री में बस इतना बहुत. आज तक एक सवाल नहीं आया रिव्यू पिटिशन पे और क्यूरेटिव पिटिशन. एक सवाल नहीं आया. ठीक है. क्लियर? ऑलराइट. नाउ let us look at the value of the judgments of the court. Just a very simple understanding of it all, it will be very clear. If the Supreme Court has to interpret, if a law is being challenged before the Supreme Court, if a law is being challenged before a Supreme Court, then you must have a minimum of 5 judges examining that law. If X law is constitutional or not, that decision cannot be taken by less than 5 judges. This is explicitly given in the Constitution under 145(3). So yesterday's question was correct because of this. The constitutionality of a law, the constitutionality of an amendment to the law, the constitutionality of an order, an ordinance, a by rule, whatever it is, if it is in the Supreme Court, would require a minimum of 5 judges. Clear? Though the Constitution doesn't talk about constitutional benches at the High Court, you would usually have 5 judges there also. इसलिए प्री में कभी हाई कोर्ट नहीं पूछते, because the number of Supreme Court judges is determined by a parliamentary law, so you have a definite number. The number of High Court judges is determined by an executive order. तो मैं minimum number judges लाऊं कहां से? Clear? Can the High Courts pronounce on the constitutionality of a law? Yes or no? Yes. But do you require a minimum number of 5 judges at the High Court as per the Constitution? No. हमको प्री निकालना है. ठीक है? नहीं, not necessary. Clear? It depends on what kind of advice it is. Na? If the president is seeking advice from the Supreme Court on the constitutionality of a law, then you would require 5 judges. Okay? No, not necessary. If that pre-constitutional treaty has a constitutional objection, then maybe. Good question. ये clear हो गया? एक second, just give me a minute. All Supreme Court judgments are binding on all lower courts, period. The ratio of all Supreme Court judgments is binding on all lower courts, period. Supreme Court judgments of a higher bench binding on the lower bench of the Supreme Court? Yes. Supreme Court judgments of a lower bench having a 2-judge bench judgment of the Supreme Court binding on a 7-judge bench of the High Court? Yes. Supreme Court hai bhai. Yes. A judgment of 7 judges of the Supreme Court binding on 2 judges of the Supreme Court bench? Yes. A judgment of 2 judges of the Supreme Court binding on a 7-judge bench of the High Court? Yes. Any judgment of any High Court binding on any other High Court? No. Can they be persuaded by it? Yes. So, a 7-judge bench of the Bombay High Court binding on a 2-judge bench of the Prayagraj of the Allahabad High Court? Clear? Good. All judgments of the High Court binding on lower courts within the territorial jurisdiction of the High Court? Yes. बस इसके ऊपर अपने को कुछ लेना देना नहीं. Clear? Understood? Yes? Good. Now, suo motu is the powers of the Supreme Court and the High Court. Both the Supreme Court and the High Court have powers of suo motu. Yes or no? Where does it come from? What is the origin of suo motu powers? Contempt. Suo motu powers of the Supreme Court and High Court are derived from their powers to punish for contempt. Logically think. And once you have those suo motu powers, you'll use it for 10 other things. Who can punish let's say, who can punish for an insult to the Supreme Court judge? The Supreme Court. So who will issue a notice for the person to be presented before the court? Supreme Court. Isn't that suo motu? It is. Clear? Good. So, both Supreme Court and High Court have suo motu powers, and the suo motu powers are essentially from the contempt of court provisions. Clear? Understood? Good. Now, we've done this for 32 and 226. Who can issue a writ for a larger number of rights? Supreme Court or High Court? High Court. Can a High Court writ decision can a writ decision of the High Court be appealed in the Supreme Court? Yes. The constitutionality of a law, can it be challenged in the Supreme Court? Yes. Can it be challenged in the High Court? Yes. Because High Courts also have the powers to issue writs under 226. Can the Supreme Court punish for contempt of the High Court of Delhi, despite being in Delhi? Can the High Court of Delhi punish for contempt of contempt of District Court of Saket? Yes. Can the Supreme Court punish for contempt of District Court of Saket? No. A lower court in a state gives you death penalty. Who confirms that death penalty? High Court. And who can get you out of that death penalty? Supreme Court. Who else can? President. Khatam judiciary. Done. This is बस कुछ नहीं है इसके ऊपर. Which now brings me to the second part, which is just 2 minutes. The courts are regulated by these laws. I told you the legal system comprises of courts, lawyers, and litigants. So we figured out our courts. We know that we've got the Constitution of India, we've got a bunch of laws, we've got a Supreme Court judgment, we've got some memorandum of procedures, and these laws also have rules. अब कोर्ट्स के साथ वकील भी तो है ना, lawyers. Now this means legal education and the legal profession. And both of this is governed by one law and one institution called the Advocates Act is the law, and the institution is called the Bar Council of India. The Bar Council of India. These lawyers work at the court, so they are essentially workers of the court. So you will have different bar councils. Supreme Court Bar Association, High Court Bar Association. Supreme Court Bar Association, High Court Bar Associations is completely different from the Bar Council of India. Bar Council of India is a regulatory authority. The Supreme Court and the High Court Bar Associations are the formal associations of the lawyers before a court. So when we enroll ourselves in a court, जब हम बोलते हैं ना we've enrolled, क्या होता है? When we write we write the Bar Council exam. Once we pass it, we take the result to get enrolled in the State Bar Council of the High Court that we want. Any lawyer can be registered in any State Bar Council and can practice anywhere. This was not the case a few years ago. Okay? So I may be registered with the Delhi Bar Council. I'm a member of the High Court. Let's say I may be the member of the High Court Bar Association, or the Delhi High Court Bar Association. ठीक है, बढ़िया डायरी मिलता है. Clear? ठीक है? But I can also go for a case to the Madras High Court. Clear? Understood? बस इतना फर्क, बहुत इतना सिंपल बेसिक फर्क है. Are we clear on this? Do we understand this properly? ठीक. Bar Councils of India versus Bar Associations, ये फर्क. तो जो आपको ये कोलिजियम को रिकमेंडेशन जाते हैं कि इनको जज बनाओ, ये इन एसोसिएशंस से जाते. क्लियर? कि दिल्ली बार एसोसिएशन की ऑफिशियल रिकमेंडेशन है कि आप इनको दिल्ली हाई कोर्ट का जज बनाए. So the collegium will call up that person, do you want to become a Delhi High Court judge? The person will say no. मेरा पर हियरिंग कॉस्ट तेरा पर मंथ सैलरी से ज्यादा है, तो रहने दे. See, always remember, we are what the judges we get. Being a judge is a calling. It is a calling. It is an absolute calling. People will have to leave extraordinarily glorious careers in litigation to become a judge. ठीक है? You'll have to register. आता है. यहाँ तक ठीक है? The overall term is lawyer. Anybody who has a law degree is a lawyer. But a person who is enrolled in a bar association and is practicing in a court of law, is a registered member of a bar association, is an advocate, governed by the Advocate Acts. So I may be a member of the Delhi High Court Bar Association, also a member of the Supreme Court Bar Association. उससे क्या होता है? पार्किंग का स्टिकर मिलता है. That's it. ठीक है, डायरी मिलता है, कैलेंडर मिलता है. होता है कि लॉयर्स के चेंबर किधर अप्लाई करते हो? इधर अप्लाई करते हो. मेरे को अपना खुद का चेंबर 2076 में मिलेगा. इतना वेटिंग. क्लियर? हाँ हाँ. आर वी डन? तो ये हो गया एड. So if there is a person who has a law degree, but is working as the general manager legal in Parle Foods, this person is not an advocate. This is a profession. The ground rule is, if you are in full-time employment, you cannot be practicing law. अब थोड़े law firms के चक्कर में थोड़े exceptions इधर उधर आ गए. You cannot be. You cannot have a salary from somewhere on a monthly basis, on a recurring basis, and be practicing law full-time. You can't be a full-time employee anywhere. Yep. You can't be. You have to surrender your license. आया समझ में? Understood? बस. A solicitor is somebody who gives you advice on the law. And this difference between a solicitor and a barrister is an English difference. A barrister is somebody who argues in a court of law. A solicitor is somebody who just gives you legal advice. तो अब इंडिया में सब मिला जुला के एडवोकेट ही है. ठीक है. बॉम्बे में अभी भी सोलिसिटर एग्जाम्स होते हैं, भाई वो ऐसे सिंबॉलिक टाइप. क्लियर? अब any lawyer can argue in any court in the country, but only a select few lawyers can file cases in the Supreme Court. They are called advocates on record. Minimum years, you have to clear an entrance exam. That entrance exam has 4 papers: the Constitution, Supreme Court judgment, Supreme Court procedures, and legal ethics. सीनियर लॉयर्स आपके पेपर चेक करते हैं, पेपर सेट होते हैं. ये नहीं कि पेपर लीक हो रहे हैं, ऐसा कुछ. सुप्रीम कोर्ट ऑफ इंडिया ये एग्जाम प्रॉपर्ली कंडक्ट कराते हैं. ही इज एन AOR, बट आई कैन ऑल्सो बी आर्ग्यूइंग विद हिम. मुझे केस फाइल कराने के लिए इनकी सिग्नेचर चाहिए. आर्ग्यू तो कोई भी कर लेगा. All the leading lawyers you would have heard of, Kapil Sibal, Rohtgi, Chidambaram, none of them are AORs. Jethmalani, not AORs. Which is why there is a larger question कि ये क्यों रखा है. The whole point of AORs was that when I came to you, Mr. AOR, to file a case in the Supreme Court, you would judge the merit of the case. Does it even deserve the attention of the Supreme Court? And you would be well versed with the facts of the case. Now what will happen is an email will be sent to you, AOR signature दे दो, stamp करना है, 50,000 rupees credited. ये. Now most AORs have become just signing authority, which is why in a legal reform it is spoken about to abolish the system of AORs. Bas. Advocate on record. The original purpose was this. अगर आप फुल टाइम एम्प्लॉयमेंट में हैं तो आप लॉ प्रैक्टिस नहीं कर सकते, इसलिए मैं फुल टाइम एम्प्लॉयमेंट पे नहीं है. फ्रीलांसर, इन्फ्लुएंसर. डन. 20 मिनट लगेंगे क्वेश्चन सॉल्व कर लें, इतने में हो जाएगा. डन. Any court, नहीं, only Supreme Court and High Court. To determine under 32, the Parliament by law can give any other court in India the power to issue writs. They haven't yet. अभी तो नहीं कर सकते ना. इसमें एक भी गलत नहीं होना चाहिए, ये घर की बात है. चलिए, अब क्रिमिनल जस्टिस भी पढ़ के जाएंगे. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate and the accused is locked up in the police station, not in jail. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. यहां हम लगाएंगे रूल नंबर 3, सेपरेशन ऑफ पावर्स. जुडिशियल कस्टडी, पुलिस कस्टडी, नाम सुनाओ नहीं सुनाओ कोई फर्क नहीं पड़ता. If it is judicial custody, then why would you keep the person in proper jail? Why would you necessarily do so? You could keep them somewhere else. You could keep them in a house. So the first option is definitely wrong. And during judicial custody, if the police officer could interrogate you without the permission of the judge, then what is the point of judicial custody? It exists because you think that the police is being a little unfair. So the answer would be 2, B only. अब ये देखिए, बहुत ध्यान से देखिए. When a prisoner makes a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. रुक जाओ. And state government have their own prisoners release on parole rules. आराम से. फर्स्ट स्टेटमेंट में हमको थोड़ी सी दिक्कत लग रही है. Whenever you get a question where the grounds are vague, it cannot lead to a definite outcome. It is, आपको पहले लाइन से ही आंसर गलत लगेगा. When a prisoner makes a sufficient case, what is sufficient? ज्यादा रो लिया तो उसके बाद का जो भी लिखा है वो इररिलेवेंट है. Parole is good behavior. So ऐसा करते हैं, मर्डर करते हैं, गुड बिहेवियर करेंगे, कल वापस आ जाएंगे. We apply question the question rule. If I've been a good prisoner, then therefore I should definitely be let out early. मेरा राइट है, तो क्या हुआ, मैंने मर्डर किया है ना, जेल में सबको मैंने मैग्ना कार्टा कराया है बस. सेकेंड, state governments have their own prisoners release on parole rules. This seems like a factual question. What is the closest piece of information that we have? पुलिस स्टेट सब्जेक्ट है, लॉ एंड ऑर्डर स्टेट सब्जेक्ट है. यस, स्टेट्स के पास अपनी लोकल जुडिशरी है, तो अपने रूल्स नहीं बना सकते. यस, criminal laws are in the concurrent list. States can also have their own criminal laws as long as they don't conflict with central criminal laws. So can the states have their own rules? Yes. The answer to this should be, ठीक है, कसम से बोल रहा हूं मुझे आंसर नहीं पता है, इसलिए मेरी भी थोड़ी दगती है. थर्ड, अब एडहॉक जज, रिटायर्ड जज पढ़ के जाएंगे तो कुछ याद नहीं रहेगा, क्वेश्चन से समझेंगे. With reference to the Indian judiciary, which means constitution has not been mentioned, we are looking at the general state of affairs. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice with prior permission of the President of India. 2. A High Court in India has the power to review its own judgment as the Supreme Court does. The easier statement to tackle here is the second one, because it is an application of court of record. If something is placed on record before you, you can review it. Yes? Apply करके देखते हैं. Can a High Court of Delhi give a different judgment on an issue that it gave 10 years ago? Of course it can. A 5-judge bench of the High Court of Delhi can overrule a 3-judge bench decision of the High Court of Delhi? The second option. Can overrule. Can I go and appeal from 3 judges of the Delhi High Court to 5 judges of the Delhi High Court? Yes. You can have an internal appeal system. In fact, High Courts do. In High Courts, you have first an internal appeal. That from a smaller bench, you go to a higher bench, and from the higher bench, you go to the Supreme Court. Second to sahi hai. First, any retired judge of the Supreme Court of India, matlab, you would have anyways fulfilled the Supreme Court qualification criteria before, and you would have had a collegium mandate before. तो जब आप थे तब आपने क्वालिफिकेशंस भी पास किया और कोलिजियम भी पास किया. You are now being called back, which means there is an urgency, there is a genuine dearth of judges. Yes, so therefore I need you. Now who makes the formal appointment? Option को break करो. Supreme Court judges are appointed by the President. ये आता है. So even if you're appointing a retired Supreme Court judge, you're appointing them back to the Supreme Court. There is a formal appointment, must be done by the President. Correct? Yes? So, बोलो. अब इनका क्वेश्चन बड़ा इंटरेस्टिंग है कि what if an 80-year-old judge is being called back? The Supreme Court qualifications don't mention judges, don't mention ages. क्वालिफिकेशन के लिए एज नहीं मेंशन करते, रिटायरमेंट के लिए करते, तभी तो रिटायर्ड है. So the one thing that will not count for rehiring a retired judge is retirement age. Yes? तो अजीत डोभाल कैसे होते हैं फिर आज? वो चले ही जा रहे हैं. Yes? अमिताभ कांत is the Sherpa of G20. चले ही जा रहे हैं. They're all officially retired. Can a retired civil servant be called back? Yes. फिर तो यहां किसने रोका है? So what should the answer be? No. What should the answer be? Are both correct? Yes. Yes or no? बहुत ध्यान से। फर्स्ट सही है। किसी को फर्स्ट में दिक्कत है? किसी को फर्स्ट में दिक्कत है? Any retired judge will be appointed by the Chief Justice with prior permission. आप अपॉइंट कर रहे हो प्रेसिडेंट को बता के, तो इन इफेक्ट सही भी हो सकता है। सेकंड में किसको दिक्कत है? सेकंड में किसको दिक्कत है? बिल्कुल कंफर्म, बिल्कुल दिल से बोल। 100% किसको दिक्कत है? और गलती कहां है? As the Supreme Court does. The High Court can review judgments of the High Court. Can the High Court review judgments of the Supreme Court? तो सेकेंड ऑप्शन सही कैसे हुआ? The High Court in India has the power to review its own judgment as the Supreme Court does. आराम से, आराम से, आराम से, जल्दी नहीं करेंगे, आराम से सोचेंगे। आप में से किसको लगता है कि सेकेंड ऑप्शन सही है? हाथ खड़ा करिए। वेरी गुड, एक्सेलेंट। लगता है? गुड। क्यों लगता है? हाँ, सही बात। Is it comparing the review powers of the High Court and the Supreme Court? Yes. Is it comparing the overall review powers of the Supreme Court and the High Court? Yes. A High Court in India has the power to review its own judgment as the Supreme Court does. क्या इसका मतलब ये हुआ that what does this mean? A High Court in India has the power to review its own judgment as the Supreme Court does to review its own judgment. ये स्टेटमेंट का मतलब हुआ? Yes. या ये मतलब हुआ that a High Court in India has review powers of its own judgments like the Supreme Court? ये मतलब तो नहीं हुआ। हिंदी में अनुवाद करिए। जिस तरह सुप्रीम कोर्ट अपना जजमेंट रिव्यू कर सकता है, हाई कोर्ट कर सकता है। हाँ, यस। द ऑप्शन इज सिंपली सेइंग इफ द हाई कोर्ट कैन रिव्यू इट्स जजमेंट जस्ट लाइक द सुप्रीम कोर्ट कैन। बस हम यहां रहे, एज द सुप्रीम कोर्ट डस। जल्दी नहीं करेंगे। गुड, करो प्रायर स्टेटमेंट से लिंक। A High Court in India has the power to review its own judgment just as the Supreme Court does. Just as the Supreme Court does. सारा खेल just as the Supreme Court does का है। अगर आपने वहां यह सोच लिया it is comparing the overall review powers, that means no. But अगर आपने वहां यह सोच लिया it is only comparing the powers to review its own judgment, then yes. क्या आंसर है? सेकेंड ऑप्शन सही है कि नहीं? किसी को सेकेंड ऑप्शन अभी भी गलत लग रहा है? आप बताओ क्यों? सॉरी, जोर से बोलिए। ठीक है, मेरे से बात कर रहे हैं ना, 1 मिनट। हाँ, हाँ, क्या नहीं है? कि रिव्यू पिटिशन और क्यूरेटिव पिटिशन हाई कोर्ट में नहीं लगते। अच्छा, एनीबडी एल्स? बट ये कॉन्स्टिट्यूशन कहाँ लिखा है? क्यों स्मार्ट बन रहा है? क्यों स्मार्ट बन रहा है? सवाल का जवाब दे। ऑफिशियल आंसर किसी मुझे लेना देना ही नहीं है यार, तूने सारा फन उठा दिया। मुझे भी पता है आंसर यार। व्हाट इज योर जस्टिफिकेशन? विच इज बट यहां कॉन्स्टिट्यूशन तो नहीं लिखा ना, यहां कॉन्स्टिट्यूशन तो नहीं लिखा है, फिर क्या करेंगे? अ हाई कोर्ट इन इंडिया, उसको दोबारा पढ़ो, ये गलत नहीं कर सकते। अ हाई कोर्ट इन इंडिया has the power to review its own judgment like the Supreme Court does. A two-judge bench of the Supreme Court can review and can give you a different judgment on an earlier two-judge bench. A two-judge bench of the High Court, can they do the same? A two-judge bench of the Delhi High Court, can they do the same? Yes. Anybody else who thinks the second option is incorrect? Anybody else? Any other reason why you think the second option is incorrect? नंबर ऑफ जजेस हटा दो, इससे कोई लेना देना नहीं। और एनीथिंग एल्स? क्योंकि अगर हमने ये मान लिया कि दूसरा ऑप्शन सही है, then we will have to get into the technicality of every option in the UPSC. इसका ऑफिशियल आंसर ए नहीं है, हो ही नहीं सकता। Can the Supreme Court review its judgment? Yes. Can the High Court review its judgment? Yes. सवाल ये है, the High Court can review its judgment, its own judgment, like the Supreme Court can? Yes. जिस तरह सुप्रीम कोर्ट अपने जजमेंट्स ओवर रिव्यू कर सकता है, उस तरह हाई कोर्ट भी कर सकता है। हाँ, सो आर वी टॉकिंग अबाउट रिव्यू पावर्स एज अ होल? नो, आर वी टॉकिंग अबाउट रिव्यू पावर्स स्पेसिफिकली? ठीक है, ये टेढ़ा क्वेश्चन था, तो अगर आप ये गलत भी करके आते हैं, अटेम्प्ट जरूर करना है, बिकॉज इट्स अ मैटर ऑफ इंटरप्रिटेशन, एंड व्हेनेवर यू गेट स्टक, ऑलवेज लुक एट द हिंदी ट्रांसलेशन, always look at the Hindi translation, because the answer to this question is what you mean from this question. On a bad day, people who are saying B is incorrect, the second statement is incorrect, would say it is correct. आपके आंसर पर डिपेंड करेगा ना, फिर हम क्या करेंगे? फंसेंगे ना, है ना सर? सही कह रहे हैं ना सर? थैंक यू सर। तो बिना 10 साल हो गए मुझे ये करते, मेरे को रात को नींद से भी उठा के बोलेगा ना, मैं सही आंसर देगा 90% ऑफ द टाइम। क्योंकि हमने क्या सीखा है अब तक, जो एक सिंपल मीनिंग है उस ऑप्शन का वो सही होना चाहिए। सो डज दिस ऑप्शन मीन सुप्रीम कोर्ट कैन रिव्यू इट्स जजमेंट, हाई कोर्ट कैन, यस और नो? यस। इसके ऊपर की सारी कहानी अप्लाइड है। समझ में आया? ज्यादा नहीं पढ़ना है। So by the powers vested in me by myself, I declare A to be the correct answer. Sorry, C to be the correct answer. Both are correct. ठीक है? Done. ठीक है? आया समझ में? क्यों आया समझ में? क्योंकि हम अपने रूल्स के साथ धोखा नहीं कर सकते। अकॉर्डिंग टू द कॉन्स्टिट्यूशन लिखा था? नहीं। सिंपल मीनिंग। सुप्रीम कोर्ट अपना जजमेंट रिव्यू कर सकता है? हां जी। हाई कोर्ट कर सकता है? हां जी। आगे बढ़ो ना जी। कई बार क्या होता है ना, बिकॉज यू हैव रेड अ लॉट, तो वो योर नॉलेज बिकम्स योर एनिमी। वो नहीं होने देना है। वो इंग्लिश में खेल, मैं बोल रही पॉलिटी है ही सी सेट का खेल। हाँ, फिर तो और भी आसान हो जाता ना। चलिए, द 44th अमेंडमेंट टू द कॉन्स्टिट्यूशन ऑफ इंडिया इंट्रोड्यूस्ड एन आर्टिकल प्लेसिंग द इलेक्शन ऑफ द प्राइम मिनिस्टर बियॉन्ड जुडिशियल रिव्यू। The Supreme Court of India struck down the 99th Amendment as being violative of independence of judiciary. मतलब ये तो उस साल का कॉन्टेक्चुअल क्वेश्चन है। चलिए, 99th was NJAC has been struck down, ये तो बच्चों को भी आता है, तो बात तो सही है बिल्कुल, है ना? आगे बढ़ते हैं। 44th Amendment was the good one. इसके it was also not even the 42nd. 39th Amendment. 42nd के पहले वाले जितने थे वो शेडी थे। हाँ, 39 to 42 में गड़बड़ करी है, 44 में समेटा है, राइट? The 44th Amendment to the Constitution introduced an article placing the election of the Prime Minister beyond judicial review. Now, even if you don't know 78, if you don't know 76, if you don't know 39, जुडिशियल रिव्यू तो कहीं लिखा ही नहीं है, तो आर्टिकल कहां से ऐड कर दोगे जुडिशियल रिव्यू का? On a sheer technicality, that option is incorrect. If an amendment was made saying that you are immune from judicial review would have been written in that article. लिखा क्या रहता था? Cannot be inquired into a court of law. यहां शब्द का इस्तेमाल किया है, जुडिशियल रिव्यू। ये टेक्निकल है, तो वही शब्द होना चाहिए। तो 44th याद रहे नहीं रहे, 42nd याद रहे नहीं रहे, जुडिशियल रिव्यू तो कहीं नहीं लिखा कॉन्स्टिट्यूशन में, तो बात ही खत्म। न कभी लिखा था, न लिखा है, कभी लिखा जाएगा भी। तो आंसर क्या हुआ? बी। करेक्ट? सही है? ठीक। With reference to the Constitution of India, consider the following statements. Remember, judiciary में वो अंग्रेजी से खेलते हैं। No high court shall have the jurisdiction to declare a central law to be constitutionally invalid. An amendment to the Constitution cannot be called into question by the Supreme Court of India. Which of the following are correct? If no high court could declare a constitutional to declare a central law, that means a central law. What is a law to be constitutionally invalid? It is violating fundamental rights, and fundamental rights could be challenged in the Supreme Court and the High Court. बस, तो इसका मतलब दिल्ली हाई कोर्ट नाज फाउंडेशन में जब 377 को डिक्रिमिनलाइज करा था, तो नहीं कर सकता था, तो नहीं कर सकता था ना, कैसे कर दिया फिर? दूसरा, an amendment to the constitution cannot be called into question. तो फिर ये पूरी केसरंदा भारती की कहानी कहाँ आती भाई? हम पागल हैं? फर्स्ट अमेंडमेंट, 17th अमेंडमेंट, 42nd, है ना, ये 24, 25, 26, करेक्ट और नो? बस ढूंढने की जरूरत नहीं है, सोचने की जरूरत है. Whatever you have generally studied so far, so the first option is incorrect, the second option is incorrect, D. अब आ जाओ. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on constitutional powers under 142. ब्रैकेट में लिख भी दिया. Which it could mean which of the following. इसका सिंपल मतलब क्या है कि अगर मुझे कुछ करना है तो मैं करके रहूंगा, यही है. ओके. Decisions taken by Election Commission of India while discharging its duties cannot be challenged in any court of law. Supreme Court of India is not constrained in the exercise of its powers made by the Parliament. In the event of grave financial crisis, the President of India can declare financial emergency without the counsel from the cabinet. State legislatures cannot make laws on certain matters without the concurrence of the union legislature. सवाल फिर से पढ़िए. आंसर तो बहुत क्लियर है इसका. ये तो है बच्चों वाला क्वेश्चन. इसमें हम लगाएंगे सिंप्लीफिकेशन वाला रूल. जब ज्यादा ज्ञान दिया हो तो क्वेश्चन सिंप्लीफाई करिए. विद रेफरेंस टू द कॉन्स्टिट्यूशन मतलब कॉन्स्टिट्यूशन में लिखा होना चाहिए. प्रोहिबिशन और लिमिटेशन और प्रोविजंस कंटेन्ड इन ऑर्डिनरी लॉज cannot act as prohibitions or limitations on the constitutional powers under 142. इसका सिंपल मतलब ये हुआ, if a law is preventing you to do something, then 142 allows you to override that prevention. यही मतलब हुआ. What would the law prevent you from doing? What kind of a limitation or a prohibition could a law create? कि the courts can't get into it. Yes, the courts can't get into the meaning of the law. और 142 याद ना हो, लेकिन 142 के आसपास के आर्टिकल्स याद है कि यार ये कुछ जुडिशरी से रिलेटेड मामला चल रहा है ना. 137, 143, ये जुडिशरी के आसपास के आर्टिकल्स हैं. चारों में से एक ही ऑप्शन है जुडिशरी से रिलेटेड. इफ यू कुड नॉट, द डिसीजंस टेकन बाय द इलेक्शन कमीशन कैन नॉट बी चैलेंज इन अ कोर्ट ऑफ लॉ, तो इलेक्शन पिटीशन क्यों होता भाई? है ना इलेक्शन पिटीशन. सी, सुप्रीम ग्रेव फाइनेंशियल क्राइसिस में प्रेसिडेंट को पूछने की जरूरत नहीं है, तो पार्लियामेंट्री गवर्नमेंट किस लिए बनाई भाई? डी, state legislatures cannot make laws on certain matters without the concurrence of the union legislature. Why? State legislatures can only make laws on state list and concurrent list. उसमें पूछने की क्या जरूरत? So what is the answer? B. Simple question है. Does anybody had a difficulty doing this? वो चाहे तो कर सकते हैं, बट उन्होंने किया नहीं. नहीं, the Supreme Court took the moral responsibility saying, I do not want to make a judgment legalizing same-sex marriage. This is something which is very sensitive, which reflects the public will, should therefore be done by an act of the parliament. जहां सुप्रीम कोर्ट को लगा कि बस पर्सनल लॉज में आप दूर रखते हो ना कोर्ट्स को, सुप्रीम कोर्ट ने ट्रिपल तलाक क्रिमिनलाइज करा था ना, फिर when it comes down to it, it comes down to it. वो केस टू केस बेसिस पे डिपेंड करता है. सॉरी, ध्यान से देखिएगा. The motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. The details of the process of the impeachment of the judges of the Supreme Court of India are given in the Judges Inquiry Act of 68. If the motion of the impeachment of the judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of 2. Third is जो हमने इंक्वायरी एक्ट, ये हो जाता, संभाल के होता, इसमें 1 मिनट लगता लेकिन शॉर्ट. We just had to sit back and not get overwhelmed with the length of the question. कि लंबा question, I'll get lost in transition. Every word has to be read very carefully. ठीक है? So the answer should be C, 3 and 4. Yes? ठीक. In India, Constitution लिखा है. Judicial review implies the power of the judiciary to pronounce upon the constitutionality of law and executive orders, the power of the judiciary to question the wisdom of the law enacted by legislatures, the power of the judiciary to review all legislative enactments before they are assented by the president, the power of the judiciary to review its own judgments given earlier in similar or review or similar or different cases. Simple question, the question लगाएंगे, our golden rules लगाएंगे, निकल आएगा. If the judiciary could question the wisdom of legislatures, it would violate separation of powers. If the judiciary could review everything before an assent, it's not even a law. So what are you questioning? Violation of separation of power. The power of the judiciary to review its own judgments is court of record. You have evolved. It could still be argued as a form of judicial review. But you judicially review the acts of the legislature and the executive. You do not judicially review the acts of the judiciary. है ना? Judicial review is a function of checks and balances. So you're reviewing the acts of the legislature and the executive. किधर है ऑप्शन? ए. बस ये बने बनाए 2 नंबर कहीं नहीं जाने चाहिए. Which of the following is the custodian? आपकी तौहीन करूंगा ना मेरी. प्रेसिडेंट, प्राइम मिनिस्टर, लोकसभा सेक्रेटेरिएट, सुप्रीम कोर्ट. सो मिल के बोलो सुप्रीम कोर्ट. The power to increase the number of judges in the Supreme Court of India is vested. Wow. President, Parliament, Chief Justice, Law Commission, Parliament. The power to increase the number of judges in the High Court would have been. अच्छा लगता है ना? Good. The power of the Supreme Court to decide disputes between center and states fall under advisory, appellate, original writ. What is the provision to safeguard the autonomy of the Supreme Court of India? While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. The Supreme Court judges can be removed by the Chief Justice of India only. The salaries of the judges are charged on the CFI, to which the legislature does not have to vote. All appointments of officers and staff of the Supreme Court are made by the government only after consulting the Chief Justice of India. Now, this is a good question. Option frameworks देखिए 1 and 3, 3 and 4, 4 only, 1, 2, 3 and 4. ठीक, तो अगर आप 3 या 4 में से कुछ एलिमिनेट कर पाते हैं तो आपका कुछ हेल्प हो जाएगा. ठीक है. While appointing the Supreme Court judges, the president has to consult the Chief Justice. Constitution में क्या लिखा है? You have to consult Chief Justice or Supreme Court judges? आज तो बताया था क्लास में. According to the Constitution, the Supreme Court judges are appointed by the president after consultation with such Supreme Court or High Court judges, whatever the case might. यही बताया था. यस, तो सीधा वायलेशन है. पहला ऑप्शन तो गलत ही है. यस, यस और नो. ठीक है, अग्रीड. बट नहीं भी लिखा हो, बट ये अज्यूम करोगे ना आप. While appointing the Supreme Court judges, the president has to consult the Chief Justice of India. ठीक है. All right. Does it say you only have to consult? No. Does it mean that the Chief Justice of India has to specifically be consulted? No. Does the Constitution mention Chief Justice of India while appointing Supreme Court, other Supreme Court judges? Provisions में क्या लिखा है? डाउट लग रहा है? आगे बढ़ो. The Supreme Court judges can be removed by the Chief Justice of India only. ये तो गलत है, तो आपका ऑप्शन डी एलिमिनेट हो गया. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature does not have to vote. ये ठीक लग रहा है? हो सकता है. You're charged to CFI. CFI पे वोट नहीं होता, सीधा पास किया जाता है. ये हमको आता है. डी. D. Sorry, fourth. All appointments of officers and staff of the Supreme Court are made by the government, but only after consulting the Chief Justice of India. ये सही लग रहा है? All appointments of the officers and staff. जजेस की बात नहीं कर. हम जजेस की बात नहीं कर रहे. आराम से करिए. तो हमारे पास इस टाइम पे दो ऑप्शंस में इश्यूज हैं. आराम से करिए. ऑप्शन 1 में इशू है और ऑप्शन 4 में इशू है. अगर ऑप्शन 1 सही हुआ तो फिर हमारे पास ऑप्शन सिर्फ 1 और 3 का बनता है, और अगर ऑप्शन 4 सही हुआ तो हमारे पास ऑप्शन सिर्फ बी और सी का बनता है. यस, यस और नो? करेक्ट. Either your answer has to be 1, 3 or 3, 4 or 4 only. यही बन रहे ना ऑप्शंस. आराम से करो और सोचो, बताओ क्या हो सकता है, क्या नहीं हो सकता है. While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. The CGI is not there, then how will you consult the CGI? You're appointing the senior most judge. Constitution में क्या लिखा है? आज क्लास में क्या बताया था? फर्स्ट ऑप्शन. हमारा प्रॉब्लम फर्स्ट और फोर्थ ऑप्शन का है ना. सेकेंड ऑप्शन तो गलत है, इसमें तो कोई प्रॉब्लम नहीं है. ठीक है, और सोचो, और सोचो. Let's spend some time on the first option. आराम से. Let us spend some time on the first option. आराम से. Let us spend some time on the first option. ठीक है? While appointing Supreme Court judges, The president has to consult the CJI. The president has to consult the CJI. Collegium is CJI +4 ना, तो अच्छा लगे या बुरा लगे CJI से तो कंसल्ट करना पड़ेगा. यस, ठीक है. ये स्टेटमेंट वही वाला स्टेटमेंट है, रिव्यू वाला है ना, रिव्यू वाला. हम ज्यादा सोचेंगे तो गलत लगेगा, कम सोचेंगे तो सही लगेगा. यस और नो? तो ज्यादा सोचना है कि कम सोचना है? तो बताओ फिर. कॉन्स्टिट्यूशन में चीफ जस्टिस लिखा है या नहीं? मैंने क्लास में क्या बताया था बेटा? क्वेश्चन में कॉन्स्टिट्यूशन लिखा है, तो क्या मुझे ब्लैक एंड व्हाइट कॉन्स्टिट्यूशन आना चाहिए? नहीं, नहीं आना चाहिए. So is it true that the president should consult the CJI? Yes. तो पहला ऑप्शन सही हो गया. तो भाई चौथे ऑप्शन में प्रॉब्लम क्या है? All appointments of the officers and staff of the Supreme Court are made by the government only after consulting. तो अब गवर्नमेंट रजिस्ट्रार सुप्रीम कोर्ट अपॉइंट करेगा. अब गवर्नमेंट रजिस्ट्रार सुप्रीम कोर्ट अप्लाई करेगा, अपॉइंट करेगा. रूल नंबर 3, सेपरेशन ऑफ पावर्स. इफ द गवर्नमेंट इज अपॉइंटिंग द स्टाफ टू द सुप्रीम कोर्ट, तो तुम्हारी फंक्शनल इंडिपेंडेंस किधर रही? यस. तो तुम्हारी फंक्शनल इंडिपेंडेंस किधर रही? और ये क्वेश्चन तो फंडामेंटली आप गलत मान सकते हो. ऑल अपॉइंटमेंट्स आर मेड बाय द गवर्नमेंट. एंट्रेंस एग्जाम नहीं होता, रिटन एग्जाम नहीं होता, फिर ये तो प्रैक्टिकली गलत है. दिस विल सीम टू बी करेक्ट, लेकिन हमारे पास कितने रेड फ्लैग्स हैं? ऑल, टू, ओनली. एक ही सेंटेंस में दे रहे थाली में भाई, ओनली. 3, अपना गोल्डन रूल वायलेट हो रहा है, सेपरेशन ऑफ पावर्स. उसके बाद भी आपको लगता है ये ऑप्शन सही है, तो माफी मैं मांगता हूं. सो 4th गलत हो गया. सो 3 and 4 गलत, 4th गलत, 1 2 3 4 गलत, 1. यही होना चाहिए. बिकॉज ये इसलिए सही है क्योंकि हमारा रिव्यू वाला क्वेश्चन का ऑप्शन भी सही. ये थोड़ी ना कहा कि ओनली है. वेरी गुड बेटा. ये थोड़ी ना कहा कि बाकियों से नहीं पूछेंगे. ये थोड़ी ना कहा कि अकॉर्डिंग टू कॉन्स्टिट्यूशन. सीजीआई से पूछ के कर रहे. वेरी गुड, वेरी गुड, एक्सेलेंट. हजाब कितने सही, हजाब राइट, हजाब कितना सही बात बोला कि क्या ज्यादा जरूरी है कि सीजीआई का जज में पूछें या स्टेनोग्राफर में पूछें. यू आर इंडिपेंडेंट जुडिशरी बिकॉज यू विल आस्क यू बिफोर अपॉइंटिंग सुप्रीम कोर्ट पियोन. ठीक है. ठीक है, चलिए. ओरिजिनल में क्या आना चाहिए? डिस्प्यूट बिटवीन गवर्नमेंट ऑफ इंडिया एंड वन और मोर स्टेट्स. डिस्प्यूट बिटवीन इलेक्शन, अ डिस्प्यूट रिगार्डिंग इलेक्शंस टू आइदर हाउस ऑफ द पार्लियामेंट और आइदर हाउस ऑफ द लेजिस्लेचर. ये इलेक्शन पिटिशन है. अ डिस्प्यूट बिटवीन गवर्नमेंट ऑफ इंडिया एंड अ यूनियन टेरिटरी. अ डिस्प्यूट बिटवीन 2 और मोर स्टेट्स. C1 and 4. पक्का? 100% पक्का? पीछे सब सही? क्या नहीं है? 2 तो नहीं है,
तो जिस भी ऑप्शन में 2 नहीं है वो हटा दो। तो या तो 1 and 4 सही है या 3 and 4 सही है, either 1 and 4 or 3 and 4. Yes, between the government of India and one or more states is center and states. Between 2 or more states is states and states. So 1 and 4, the option should be C. ठीक है? Last question. The Supreme Court of India tenders advice to the President on matters of law or fact on its own initiative if you seek an advice only if the matters relate to fundamental rights of citizen. कानून में क्या लिखा है? पूछेंगे तो बताओगे, अपने मन से सुप्रीम प्रेसिडेंट को फोन नहीं करेंगे, हेलो, तो आंसर क्या हुआ? 2 ओनली। बस। तो जुडिशरी में क्या ध्यान रखना है? ये जो हमने आज सीखा, द सिंपलेस्ट आंसर इज द करेक्ट आंसर। डन।